Good morning, everyone. Welcome to the Michigan Court of Appeals. This is the first day of case call for panel one of the court's June 2026 session. My name is Miriam Bazzi, and I'm joined here today by Judges Michelle Rick and Allie Greenleaf Maldonado. We understand that these cases are important to the litigants and counsel, and I want to assure you that they are important to us as well. We have been diligently working on these matters. We've had the benefit of your briefing, as well as the work from our research division and chamber staff. We are familiar with the relevant facts and pertinent law, and so we ask you to focus oral arguments today on your most salient points, why you should prevail, and what is critical for us to understand. Finally, we are hearing matters involving sexual assault victims, personal protection orders, and children. Before these proceedings are recorded, we ask you to please use initials rather than the actual name of any victim, child, or other vulnerable individual in those cases. And so right before I begin, I actually left my glasses.
Oh, sure.
Right.
Beautiful day today, isn't it?
Now with that, we look forward to hearing your arguments. We will resume by calling case number one, docket number 379136, Republican National Committee versus Secretary of State. Good morning, Counselor. How much time would you like for rebuttal?
I'd like to reserve 7 minutes for rebuttal.
All right, let me just set the time. You may begin.
Morning, may it please the court. Assistant Attorney General Eric Grill on behalf of defendants Pelley's Secretary of State Jocelyn Benson and Director of Elections Jonathan Brader. This is a case that concerns the invalidation of absent voter ballots based on missing or mismatched numbers on perforated ballot stub, even without any knowledge of or fault by the voter. These ballots have been sealed in envelopes that are signed by the voters and whose signatures have been verified by the local clerks. And it has been the Secretary of State's, it has long been the Secretary of State's guidance that these ballots would be tabulated in a manner similar to challenge ballots.
And in fact, the procedure has been in place prior to the time that the current Secretary of State was in office.
Very much so, Your Honor. I believe at least since 2009, as far as I'm aware.
Thank you.
The plaintiffs in this case have claimed that the guidance is invalid because it is contrary to the election law. However, the applicable statute says nothing prohibiting these ballots from being tabulated. In its orders granting summary disposition to the plaintiffs and issuing a 10-step remedial injunction, the Court of Claims below erred in at least two main respects. First, in holding that the Michigan election law did not permit the tabulation of ballots with missing or mismatched stub numbers, the court impermissibly both added and removed words from the statute, and its interpretation conflicts with several provisions of the Constitution preserving the right to vote in absent ballot. Second, the Court of Claims abused its discretion by issuing a permanent injunction when there were other adequate remedies available and without any showing of irreparable harm to the plaintiffs, and without balancing the harms that would be caused to the defendants and others by mandating procedures that both conflict with state law and would be impractical to implement.
And if we could, I mean, there was never a prior hearing for a temporary restraining order or any kind of evidentiary hearing upon which that relief was granted. Am I correct?
For the injunctive relief, that's
Yes.
correct, Your Honor. There was the court issued its order on the summary disposition, ordered for supplemental briefing about addressing remedy, and in the Secretary of State's brief, we specifically asked that there would be some type of hearing or conference to discuss the options, and there was not one.
Nor was, if I'm reading the record correctly, so please correct me if I'm wrong, but as I understood it, both parties submitted remedy proposals simultaneously. Am I correct about that?
That is correct, Your Honor. We did not see the plaintiffs, the RNC's proposals before it went to the court.
And as I understand your position, at least as it pertains to that permanent injunction, counsel, um, Secretary of State, there are some barriers to implementing that 10-point proposal. Is that correct?
That is correct, Your Honor. Not the least of which is that it requires the utilization of programs that are simply not available. For example, it requires the state to make EDARP, the electronic delivery and delivery and return portal, which is a system that was designed for use of active military and merchant marine to return their ballots. It requires a Department of Defense certified signature for it to operate. It's not designed for the use by ordinary everyday citizens. And in fact, Michigan election law prohibits it from being used by anyone else other than active military. But the injunction requires us to make it available now to address and remediate.
Has the Secretary of State undertaken any cost analysis relative to implementation, and how does that correlate to the number of actual AV ballots that potentially are problematic with the numbers not aligning?
Do not believe there has been a formal cost analysis performed yet, but it would definitely would require the reprogramming of the system and the implementation of a new way of identifying and certifying these voters, which doesn't exist yet. So we are talking considerable expenses to develop basically a whole new program. And
That program that you were talking about that requires a military signature, is that requirement based on a regulation? Maybe federal law or something like that?
well, it's certainly, part of it is required by Michigan law.
Or Michigan?
The Michigan statutes themselves provide that, the adoption of this program was somewhat contentious because there were concerns about fraud and wanted to make sure that people who use the system are in fact who they say they are. This has been a topic of some controversy in recent years. So part of when they adopted the statute, they included that in the law to say this can only be used by military members. And getting back to your question, Judge Rick, the idea of how many ballots we're talking about, we don't have solid numbers for statewide, but in response to the Court of Claims request, we looked at about, I think, 115 precincts in the course of the 2024 election. And out of those precincts, there were approximately 30 missing stubs and maybe about a dozen mismatches.
Thank you.
So it is not a large number. This is not a frequent occurrence.
All right, thank you. I kind of steered you on the path to talking about the permanent injunction. I'm going to let you talk. So I don't know if you want to continue on or if you want to move on to the other issue.
Certainly, Your Honor. I will go. Let's go start from the beginning. We'll talk about the statutory interpretation. The central question here is whether or not MCL 168, Section 768, requires that ballots with missing or mismatched stub numbers cannot be tabulated. There are many reasons why a ballot may have a missing or mismatched stub. It might have fallen off and be stuck at the bottom of the envelope. Some spouses or family members might have inadvertently swapped ballots before returning while voting and before returning the ballots. Or more pointedly, the clerk might have simply recorded the wrong number in the QVF when they sent the ballot out. So there's not necessarily any knowledge or fault on the voter for the fact that this ballot stub is missing or doesn't match the number that's been recorded. Notably, Section 768 does not specify what happens if the ballot stub is missing or does not match. The statute is
I'm
effective.
going to stop you for a second. What do you make of the language just preceding the language regarding the tabulation, the fact that the Secretary of State is required to make sure that the ballot number matches what is on the envelope? So what do you make of the fact that there is that requirement, and then right after that there's it's indicated that the Secretary of State shall tabulate the ballots? Why would you include that matching process if it's not required to tabulate, I guess?
Well, I want to point out, it's not the Secretary of State that's doing this. It's actually the local election inspectors at the time when the ballots are being done. And what it says is that if the numbers match, then you remove the perforated stub and you process it for tabulation as directed by the Secretary of State. It doesn't actually condition the validity of the tabulation on the matching. It just says, if it matches, you do this.
And there's another section that actually talks about what happens if there isn't matching. Isn't that correct?
That's correct. The section 765, 766, and 766A go into great length about the process of how the local clerks are supposed to verify the signatures on the exterior of the ballot. And then in 765, it goes into that this is how it's compared. And in 768, the first two sentences say, this has already been done. That by the time before we even open the ballots and see that the stubs are missing or mismatched, the local clerks have already verified the signature, have already confirmed that this is the voter's signature, and therefore this ballot has been approved for tabulation on the basis of the voter's signature. And that's not accidental. The statute was amended after the Constitution was amended to adopt several new voting rights, one of which was the right to, when voting an absent ballot, prove your identity by your signature. So the statute, when it says, has the local clerk verified the signature? That's the methodology by which we prove that this voter's signature is genuine and that this ballot is genuine. That's very much intentional. So the statute's silence with respect to whether or not, if the numbers don't match, what do we do with it? Does require some interpretation, but it doesn't mean that the statute doesn't give us any guidance about how this is supposed to work. The plaintiffs in the lower court have focused on the sentence in 768 that says, if the numbers don't match, or if the numbers match, then tabulate. And the inference they draw is that if the numbers don't match, then you don't tabulate. But that if not part is not in the statute. And you would certainly expect it to
If
be.
only,
I'm sorry?
the only is inserted.
Right. The idea that you tabulate only if they match. That part is just not in the statute.
So what's the point of the language if? Well, why did the legislature put if in there? It can't be surplusage, so what does it mean?
Well, I think it means exactly what it means is that if they match, you remove the perforated stub and then you process it for tabulation in the manner directed by the Secretary of State. If we would want to see something to say if they don't match and then not tabulate, I would expect to see the legislature specifically say as much as the legislature did in section 797A when we're talking about in polling places. If you vote in person and the stub falls off your ballot,
So they're just telling you to take off the tab. So
right. This is what you do. If they match, you proceed, then you tabulate in accordance with the direction of the Secretary of State. Those are the only actions that are made conditional on the matching of the numbers.
but then they use if the ballot numbers match. They should always take off they should always take that other part off before they insert it to the tabulator, no?
They should always, but then again, what I would expect to see, if the legislature was going to say this is conditional, if the numbers don't match, we're not going to tabulate it. I would expect the legislature to say exactly that, as it did elsewhere for in-person voting, where if I go to my precinct, if I go to my voting place and my stub is no longer attached to my ballot, when I come up to tabulate it, they will stop me, they will spoil the ballot. And the statute says it's spoiled and they shall vote another ballot. The legislature knows very well how to make it abundantly clear what happens in the consequence and that this ballot won't be tabulated. And it didn't do so here. We have to believe that that was a deliberate choice when the legislature uses language in one part of the statute and doesn't do it over here.
So, Mr. Grill, I think that without putting words in their mouth, the RNC would say that we are attempting to preserve the integrity of our elections. So given that you've now given us a tutorial on what happens in terms of ballot spoilage if I vote in person and my tab is missing, what happens to these AV ballots?
But in the event of an AV ballot with a missing or mismatched stub, under the Secretary's pre-existing guidance before the court's injunction in this case, the directive was to treat them in a manner similar to challenge ballots, meaning we'll take this ballot, we will make a note of the ballot number, we will process and tabulate it, and it'll be here. And if we want to come back later on, if we come to find out that there is something, all of a sudden we used to have 5 or 6 of these, now we have 100. Like something is wild, we can actually investigate and pursue it after the fact, but we would still tabulate the ballot in compliance with what the statute says, both that the fact that these ballots have already been approved for tabulation before the envelopes are even opened, and also the explicit directive of the statute that says each ballot must be inserted into the tabulator.
So in common parlance, for the simpleton on the panel here, tabulation in my brain means register the vote.
Tabulation in this case is just inserting it in the machine. And
It
then
does not mean that whatever is designated on that ballot sheet is counted then?
right, the votes are counted, that the votes are, that ballot is inserted into the tabulator, it reads the votes and it ticks for each candidate who they voted for.
Okay, thank you.
Now, so by saying only if the court first impermissibly added language to the statute and then also ignored or rendered null the parts of the statute that say the ballots are approved for tabulation but on the basis of the signatures on the outside of the envelope, and also the part of the statute that says each ballot must be inserted in the tabulator. Those words have to be inserted, have to be given some credence, and the lower court's opinion below simply did not reconcile its conclusion with this explicit statutory language.
So if the vote the votes are tabulated and we have these mismatched numbers, again, I'll ask maybe more pointedly, how does that preserve the integrity of the vote? Or what is your response to that argument, please?
First off, I think the big issue is that the missing or mismatched stub does not really address the validity of the vote. Because again, we have a sealed envelope that's signed by the voter and that signature has been verified by the local clerks as matching the voter's signature in the QVF. So we have already, before we even open the envelope, this signature has been verified, the voter has proven their identity, and there's no reason not to think that whatever is in that envelope is the voter's ballot. But in addition to that, because of the irregularity, fact that there is a missing or mismatched stub, it's accounted for by treating it as a challenge ballot so that we have a record of what this ballot was and we have a means of following up on it if there needs to be an investigation after the fact. If a candidate seeks a recount on the basis of fraud or error, there is a way to go back and see like, hey, something weird happened here that all of a sudden we had this giant surge in missing or mismatched stubs. We think something was going on and we want to investigate it. We have the ability to do that. It has never been necessary because there simply have never been enough of these to make a difference in any election.
Thank you.
Is the information on how many of these ballots may be out there, is that readily available for people to go look at or to ascertain?
These are all public records. The ballots are always available. It hasn't been tracked specifically in a neat report that can say this is how many we have in this particular circumstance. We only had a limited number of precincts that we were able to review. But this information is available and local clerks are able to produce it and it is capable of being produced. It just oftentimes isn't because most often people aren't interested and there's not a reason to be.
You mean you weren't able to review them because of time, or what was the reason you couldn't review them?
It was partly of time and partly was a matter of what the local clerks, because again, all elections are ultimately administered at the local level and what they actually kept and retained in terms of looking for this. We would have to go back and perform that review manually ourselves, and that just was not able to be done at the time the court asked for it to be done.
So going forward, assuming the process were to stay in place, are there systems being put in place to better track this information so it is more readily available for people who request it?
We can always improve our processes. It's never a matter of we're not interested in knowing more. It's always adding to it. I think I'm not aware of a specific change that addresses this specifically, but certainly it could be addressed in different ways. Now, the difficulties with the lower court's interpretation are highlighted by the fact that it also conflicts with several constitutional provisions. As a general rule of statutory construction is that the legislature is presumed to know and legislate in harmony with existing law. We have to assume that the legislature knows what the Constitution requires and when they legislate, they're doing so in light of that language. First, the lower court held that missing or mismatched ballot stub number calls into question the identity of the person who cast the ballot. That was apparently what the court's concern was, that, hey, maybe somebody else other than the voter voted this ballot. But Article 2, Section 4, 1H explicitly provides that the voters have the right to prove their identity when voting an absent ballot by providing their signatures. As I mentioned before, that's provided by statute in section 765, 766, and 766A. It's also referenced in the first two sentences of section 768. But Article 2, Section 4 does not, however, include any requirement for voters to prove their identity through stub numbers. Ballot numbers simply cannot be used as a precondition or as a way to prove the voter's identity, and the lower court erred in doing so when the Constitution explicitly provides the methodology that the people have adopted for how voters' identity is supposed to be verified. Second, the lower court failed to square its interpretation of Section 768 with the constitutional right to vote an absent ballot under Article 2, Section 4.1h. In fact, Article 2, Section 4.1 provides that the rights in that subsection, including the right to vote an absent ballot, are self-executing and are to be liberally construed in favor of the voter's rights to effectuate its purposes. So to the extent there was any ambiguity, any doubt, the benefit of the doubt should have cut in favor of the validity of the voters' ballots. Instead, the court went the other way. In addition, Section 1A prohibits any person, arguably including the legislature, from enacting or using any law, rule, regulation, qualification, prerequisite, standard, practice, or procedure, or engage in any harassing, threatening, or intimidating conduct, or use any means whatsoever which has the intent of or effect of denying, abridging, interfering with, or unreasonably burdening a fundamental right to vote. But as interpreted by the lower court, Section 768 would require the rejection of AV ballots with missing or mismatched ballot stub numbers, even when there is an obvious explanation, such as a swap between spouses, but even when it is the result of an error by the clerk through no fault of the voter, and even where the defect would not be discovered until election day, leaving little time to notify or allow the voter to then vote another ballot. And in the case of an absent voter who is out of the jurisdiction or who has mobility issues, it effectively eliminates their ability to remedy the vote at all. This raises serious questions about whether the statute, as interpreted by the plaintiffs and by the lower court, unreasonably burdens the right to vote by absent ballot. The lower court was clearly aware of this risk and even tried to address it through its injunction. There are other problems with the injunction, but the simple fact that the lower court thought that an injunction was necessary at all to preserve or protect voters' rights implicitly recognized that the reading 768 to mandate the ballots with missing or mismatched stub numbers was likely to result in voters being disenfranchised and in their rights under Article 2, Section 4 being violated. That raises serious doubts about the constitutionality of the statute as interpreted by the lower court. The Supreme Court has held that whenever possible, courts must interpret a statute not only to avoid the conclusion that the law is unconstitutional, but to also avoid doubts about its constitutionality. That's in People v. Nix, 479 Mich 112, page 124. By trying to construct an injunction to avoid the unconstitutional effects, the lower court only confirmed that its interpretation of the statute was an erroneous application of the principles of statutory construction. In contrast, the defendant's position, their interpretation of Section 768, avoids any unconstitutional burden or effect because there's no burden on the voter when the ballot is tabulated. So when you consider the lack of any clear statutory authorization to reject ballots with missing or mismatched stub numbers, the language in the statute that affirmatively provides that the ballots are approved for tabulation based on the voter's signature and explicitly directs that each ballot must be inserted in the tabulator, and the unconstitutional implications that the lower court implicitly acknowledged by writing an injunction trying to avoid them, the lower court's interpretation of Section 768 was simply in error and must be reversed.
I wonder if you could talk very briefly about another case that is now pending before the United States Supreme Court, and that is the Weitzel case and the potential impact that a decision in that matter, which requires no grace period if the RNC is successful, there is no grace period to count ballots, even if they were mailed timely. Can you reconcile that with the existing permanent order that the Court of Claims put in place? So if the RNC prevails in that matter, what does that mean for all of this case?
An excellent question, Your Honor, and I think probably the best answer I have is that it is unclear, but there is certainly conflict here where if the Supreme Court says that, as Your Honor said, there's no grace period. Election day is election day, and that's the end of it. Here we have a permanent injunction that not only allows, but requires voters to not merely confirm their own already voted ballot as being genuine, but requires them to vote a new ballot. They're given a fresh new ballot sheet to fill out all the new bubbles all over again, up to 3 days after the election is over. And the results are largely known at that point. That's unprecedented.
Counselor, you're at 7 minutes.
I'm at 7 minutes. I think I will borrow probably 1 more minute back, and just to address very quickly, I think the biggest problem with the injunction is the fact that injunctive relief was unnecessary entirely. There were other adequate remedies, specifically the declaratory relief, which is what the plaintiffs asked for in the first place. The Supreme Court has held that declaratory relief is usually enough to induce the executive branch to conform its conduct to the law, because they have all taken oaths of office to fealty to the Constitution. There was no reason why declaratory relief here, telling the secretary, if this is what the statute means, any instruction contrary is invalid, go make new instructions. That would have been enough. There was no reason that couldn't have worked here. And I think that as a premise, you can't get to injunctive relief when you have this existing alternative remedy. And in addition to that, I would direct the court back to our brief on the total absence of any demonstration of irreparable harm to the plaintiffs. The court's entire focus of irreparable harm was directed to third parties. There's never been any showing that these plaintiffs would be irreparably harmed, and that would be a prerequisite to any type of injunctive relief. Thank you.
Morning, may it please the court, Jonathan Koch, on behalf of the plaintiffs' appellees. I'm joined by my colleague, Daniel Ziegler. I think as I was preparing for this argument, one of the things that stuck out to me that I think the trial court hit on, that I don't think has really been recognized by amici or opposing parties, is that when there's a mismatched stub, there are likely two voters affected. There's the voter to whom the envelope was issued, and there's the
Signature is on it and they've compared the signature.
yes, right. The person who so they were issued one ballot, one envelope, right? And at this point, their identity has been verified. When the ballot has come back to the IV count board, it's been verified by the clerk's office. We know that voter signed that envelope. No dispute. But when there's a stub mismatch, that ballot wasn't issued to that individual.
And when you say stub mismatch, you mean for those instances where the envelope is opened and there's actually a stub
Yes.
inside, because that's one of
Yes.
several scenarios.
Right. So when the election inspectors open the envelope, they pull the ballot still in the secrecy sleeve out. They compare the stub number on the ballot to the ballot number on the return envelope, and they don't match.
What about if there is no stub? Then do we conclude that's two voters?
We can't know. I mean, we don't know, because there's no way, and that's one of the tricky parts of this. But I just focusing on when there's a mismatch, that ballot was issued to someone else. So by the time we get to envelope and ballot that are mismatched, that means there's another envelope out there and another ballot out there, because there were 2 AV ballots issued. There's 2 ballot numbers associated with that, and we don't have the information about what that looks like statewide. It's not tracked. It would be great. It'd be great if it was. The Court of Claims encouraged the parties to perhaps maybe track that. We don't do that.
But how many, okay, I seem to recall there was a pleading, and I'm not going to play with my computer to find it right now, but there was the chart of the exemplar. You know what I'm talking about? Awesome. And with respect to that chart and the exemplar, do we know how many of those those numbers where the issue has been identified as a whole? How many of those are the wrong tab in the
So-
envelope versus, the other possible outcomes?
So of the 144 poll books that were reviewed, I think it was 100, I think Brother Counsel said it was 115 jurisdictions. And I think that represents a few thousand ballots. There were 30 missing stubs, so ballots returned without a stub. There were 13 mismatches. And of those 13 mismatches, 2 of them were a husband and wife who had switched. So we had both ballots, we had both envelopes. And one of the mismatches was a voter who, I don't know if it was 2 ballots in one envelope but it was a ballot. The ballot that was returned had been issued to a voter who lived at the same address. So the clerks and the secretaries, the plaintiffs concluded that there were 3 explainable mismatches.
So
That-
that seems nominal to me. And why would we have this process that totally appears to upend the existing system and to place financial hardship on the local clerks who really are the ones managing this? It is an SOS.
So respectfully, I don't think that voters' ballots not being counted is nominal. I mean, that's my answer. We don't know if that sample is representative. If it is representative, we would expect, I think I'm not great at math, but somewhere in the 400 range of ballots statewide that would have mismatched stubs, and then several times that would have missing stubs. So I'm speculating maybe, or maybe reasoning from conclusions. Maybe that's conjecture, not speculation. So I don't think it's nominal. And even if we know that's 10 voters, 10 ballots that were returned. And because they're unexplained mismatches, which means it's not a husband and wife, it's not someone at the same address, it's not someone where the clerk said, oh, I issued the wrong ballot. It's unexplained. That means there's 20 voters affected. And if we just count those 10 ballots, there are 10 voters disenfranchised. So, I mean, you said that we care about election integrity. Of course I do. I think everyone does. We both do. We just have different ways of trying to figure out what that means.
Getting there.
Um,
Did you find the Secretary of State's fix on the injunctive, piece? Was that palatable? And if not, why not?
what fix do you mean? Like-
I mean, before the Court of Claims issued its permanent injunction and both parties had to submit fixes on the same day. Did you look at theirs, and is there a problem with it?
So I think the problem, I did look at theirs.
Thank you.
welcome.
Compound question. Thank you.
Yeah. And I think that the part of it I found problematic is, if memory serves, they would treat them as I'm blanking on that. Provisional ballots, thank you. And there was a kind of 3-step process. They would try to get an explanation from, I believe it was an explanation from the clerk, an explanation from the voter, and then kind of if they couldn't find an explanation, the Board of Canvassers could decide to count them kind of in the absence of an indicia of, and I think that's the part of it that I think is the problem, because it puts I guess, I don't know, loads the dice, I guess is a cliche. It presumes that ballot is going to be counted if there isn't proof of fraud. While you could get a mismatched stub through fraud, that's possible. You can also get it through a mistake, or an innocent mistake even. But even if there's an innocent mistake, there's still a voter out there whose ballot isn't being counted, whose vote isn't being taken into consideration.
Isn't the remedy that was proposed, doesn't that create many more issues, though? I mean, there are 3 specific sections of the remedy that is proposed that completely violate the current statute, regarding one being the absentee voters using the manner in which servicemen that are out of the country. And I believe while it indicates that you can vote absentee just because you live out of the country with the proper paperwork, you can't vote with an electronic signature unless you are a serviceman or on maritime, and there's upon proof. So it actually quite limits who could take advantage of that per the statute, but we're saying we're just going to make it available to people based on the remedy that was proposed. The other thing is the on-demand ballots. I believe the statute limits on-demand ballots to 3 situations, none of which are covered in the remedy that was proposed. And I think there was one other, I know there was one other section. I just have to find my notes on it. And so doesn't the remedy create many more issues and potentially lead to more voter disenfranchisement than what the Secretary of State has proposed?
So I think with respect to the first part of that, you're right. There isn't a statutory framework that directly addresses this. If there was, we wouldn't need an injunction because that would be the statutory process that would apply. So to some degree, addressing this problem required some coloring outside the lines. So I think the EDARP, I think the BOD voting is the closest analogy we have. And I think in the same way that as the Secretary acknowledges, the challenge ballot statute doesn't apply to this situation either. And so they're taking something that's close, that's the most close, that's the most analogous and applying it to a situation.
But there is a difference in the 2 statutes, because the statute that has been the round peg in the square hole here is limiting. It says, only persons with this credential may use this system. And, you have that kind of limitation with their option.
I don't know. And I think that with respect to that, well, it does, and again, I don't have the language in front of me, so
That's fair.
apologize me for stepping out on a limb.
No. I actually appreciate, if you don't know, I appreciate you saying you don't know. I respect that. I'm gonna look it up later. I'd rather you do that than tell me something that's not true.
But I think with respect to EDARP, I guess my point would be the statute does not allow non-service members or it imposes restrictions on using that system to cast a ballot generally, right? And I think that this is a situation, and I think this addresses, I don't know if it's Weitzel or Watson v. RNC, that case.
RNC v. Weitzel.
All right. I think the issue in that is, and the distinction between this case and that case, and the reason I think that the statutory restrictions on EDARP or BOD voting would apply is we're not talking about someone casting a ballot for the first time. Yeah, I mean, the best fix we could come up with was cast a new ballot, but someone who submitted a ballot. We know that something received at the clerk's office before 8 p.m. on election day. That's different than even if they mailed it on election day, it wasn't received by the clerk. So I think that's the distinction between Watson and Weitzel is here we have someone who tried to vote and before election day, and there was a deficient ballot. So this is more akin to a situation where at the absentee voter counting board, they find a ballot return envelope where for whatever reason the clerk's office didn't verify or there's no signature. In that situation, even though we're now after 8 p.m. on election day, that ballot still, that the person gets to come in and say, yep, this is my, or they sign the ballot, or they get to say, yes, that is my signature. I was hopped up on caffeine when I signed it, somebody was shaky or whatever. Like they get to cure that ballot after election day. That isn't them casting a ballot in the first instance in election day. And I guess as I was putting together the proposed and final order or our supplemental brief, my thought was that this is the closest analogy to that situation.
I'm going to push back on that, counsel, because I don't see, I don't follow that analysis. The Mississippian who's sitting at their kitchen table, who fills out their ballot, puts a stamp on it, the post office date stamps it before the election, the position that you have taken in that matter now pending before the United Supreme Court is,
My client, not me.
I know, not you personally, but your client's position is it doesn't count, period. If it comes in after that date, it doesn't count, even though they, filled out the ballot before Election Day. So I'm really straining to see the rationale, or say, or you're understanding the rationale for this is different than Weitzel.
Oh.
And here, 3 days afterward would be under your proposal when the fix would happen. And I don't mean that in a negative way, but you know what I mean, the cure.
Yeah,
Right?
yes.
Okay.
So, and I guess to push back to your pushback, which I guess I'm not supposed to do, or I'm not,
Yeah.
I'm supposed to do politely. I think I mean, that's how it works in Michigan, right? We have, if you drive around, there's ballot drop boxes. Those drop boxes get closed at 8 p.m. If the ballot isn't returned, if you filled out your, we're election attorneys, we vote either early voting or absentee voting, or we don't vote. If I fill out my AV ballot and I want to go to the, and I fill it out and I'm going to do it before 8 p.m. and I hit traffic and it doesn't get in the Dropbox, or I don't return it to the clerk's office, or I don't take it to an election day precinct and I don't return it, even though I filled it out, my ballot isn't going to get counted because it was received too late. And I think that's different if in my haste to return it, I forget to sign the envelope. I stick it in the Dropbox at 7:45 on election day. It's timely received and it's just not signed. It's deficient because it's impossible to verify my identity. At that point, the clerk's office receives that ballot, goes, Mr. Koch didn't sign it. They contact me through whatever mechanism is available in the QVF. Hopefully I've my cell phone or email or whatnot. I have 3 days to cure that. If I within 3 days come in and sign it or cure, my ballot counts. If I don't, it doesn't.
But we're not talking signatures. We're talking about tabs.
But I think that I realize they're different, but I think that, I guess that's the closest analogy we have. And that's why I'm talking about that as much.
If so let me ask you this. If there is, if we were to find, and we haven't even gotten to the first issue in any detail yet, but assuming we buy your argument on the first issue, but we think that this, for whatever reason, the injunction was improvidently granted or it's problematic, why not allow the Secretary of State to take it back and to finesse it? What is the problem with that, particularly given that we now have a stay?
So can I ask for clarification?
Yeah.
Are you saying, if assuming we went on issue 1,
Right.
yay, are you suggesting, proposing, whatever, either that would be the end of it and the case would be over, or we'd go back to the trial court for further proceedings?
No, I guess my assumption is that we would resolve this in its entirety and allow the Secretary of State to implement some procedure that is less costly, less taxing on the locals, and accomplishes the same goal, which is preserving voter integrity and not disenfranchising our voters.
I mean, like, if you're asking me, should I take half a win?
Yeah, would you live with it?
I mean, ultimately, and I'm not trying to be flip, I have to live with whatever you do, right? As I hope is clear from how we've litigated this case, like, we do take this seriously. We're not trying to disenfranchise people. We're trying to make sure that people have an opportunity, that their constitutional rights are respected. I hope that's clear. I will take whatever process. I mean, I'll take whatever process accomplishes that goal. I don't, however, I don't think that Judge Swartzel abused his discretion. And so I do think that the injunction as written doesn't fall outside the range of reasonable outcomes. And sorry, I'm got a little off track here.
Talk about your first issue and why each ballot only means each ballot that has the tab attached and the numbers match.
Sorry, what?
Talk to me about the statutory provision.
So I think that there's two relevant points about what, I guess there's three relevant points about what this statute means. So it says, and I'm going to paraphrase it, when the ballot comes to the absent voted county board or wherever the election inspectors are processing these ballots, the first thing they do is look at the sealed ballot envelopes. They double check that there is a voter signature on it and that the clerk's section of the envelope is filled out. And that means that the clerk's office, I think, noted the date it was received. They've checked a box or signed or verified that they verified the signature, right? So the clerk's office is the body that compares the signature to QVF. All right, so the election inspectors double check that that's filled out. They double check there's a signature. If both of those things are matched, then they move to the next step. If they're not, they go back to the clerk's office and say, hey, this needs to be fixed. I think we've actually litigated that. At that point, we get to the statute. If the ballot numbers match, then the election inspectors can prepare it for tabulation in accordance with the Secretary of State's instructions.
And that's my question. If the ballot number match, the second sentence doesn't have that qualifying language. It's a mandate that the ballot be tabulated.
Which section?
168.
No, sorry. Which sentence?
The second sentence.
Each ballot must be inserted into the tabulator.
I mean, this was not beautifully written. Like this was like a statute dying to be part of litigation.
The legislature, in its infinite wisdom, wrote this statute with aplomb. So,
We assume they know what they were doing and they meant what they
Right.
said.
But it says each
So-
ballot must be inserted into the tab.
I think there's,
Not telling you to throw away or do anything else with the other ballots.
two points. One is looking at the statutory history. So if we go back to what the statute said before the recent changes, before the if the ballot numbers match language was added, it said that after examining each envelope containing an absent voter ballot or ballots to determine that such vote is legal, the election inspectors, quote, shall open the absent voter's envelope, take out the ballot or ballots contained therein, and shall, without unfolding such ballot or ballots, detach from each such ballot the perforated numbered corner and shall deposit each such ballot in the proper ballot box. So under the pre-2023-2024 version, it said, you take the ballot out, you detach the stub, you put it in the ballot box, the proper ballot box to be tabulated. So pre-2024, pre this recent change, it didn't expressly state that the number needed to be compared to anything. In 2024, they amended the statute to say if the ballot numbers match, then it can be prepared for tabulation in accordance with the Secretary of State's instructions. Each ballot shall be inserted in the tabulator. So I think that they added something, and they added the comparison, and I think that if is matter. I'm going to quote from, I hate reading case law, but I'm going to quote from In re Casey Estate. The legislature's use of the word if at the start of the subsection and the relevant clause is critical because, quote, the use of if sets forth the alternative conditions upon which the rest of that subsection is premised. Absent satisfaction of one of those conditions, the remainder of that subsection does not come into play. And then in Judge Gleicher's concurrence in a state of Coral, notably the statute begins with the word if. The word if at the outset of MCL 462.3171 sets forth a condition upon which the remainder of the subsection is premised. Absent satisfaction of the stated condition, the remainder of the subsection simply does not come into play. So my answer to each ballot shall be inserted to the tabulator is because it occurs after that if statement, if the ballot numbers match. That each ballot shall be inserted into the tabulator, that only comes into play if the ballot numbers match. It is downstream of that.
What about the language that is clearly missing? They could have put if the ballot numbers don't match, as they did in the other section regarding ballots that in-person voting. So, I mean, shouldn't we presume it was done intentionally, that they still intended by saying each ballot must be inserted into tabulator to have those ballots counted?
I do not think, I don't agree, obviously. And I think that that's the action of the negative implication canon, right? By saying if the ballot numbers match, the inverse of that is if the numbers don't match, you don't tabulate. And so, and I think that is the necessary implication of that if statement, because otherwise, and if we take their argument and say, well, it is silent on whether a ballot with a missing or mismatched stub can be tabulated, and you don't need to, that. I don't see the work that language does, right? If each ballot shall be inserted by the tabulator prohibits, requires, they argue, that ballots with missing or mismatched stubs have to be tabulated. I don't see the work that ballot matching requirement is doing. I think that reads that language. I mean, that turns that into nugatory and surplusage language. I just, and I think that when you look at the Michigan election law as a whole, we see that the legislature, the policymaking branch of our government, decided that ballot stubs matter, that they are an important framework for ensuring that the ballot that is returned was the ballot that was issued to the associated voter.
Remind me of the date again, please, of that amendment.
I think it was a 2023 public act, and it became February or March of 2024. I think it was February.
What to the point that Mr. Grill made about how there is a way to isolate out, to designate, so that if there are some irregularities, they can be investigated. When you say it just gets counted and case closed, that's not exactly how the process works, because if there is a voting irregularity or if there is a recount, they can isolate those ballots for that purpose, correct? Yes or no, correct?
Yes.
Okay, so what's the problem?
The problem is that the nature of the legal framework for dealing with challenged ballots only applies in the context of a contested congressional election. We showed that in our brief. And even then, so even if you get to the extraordinarily rare, extremely limited judicial proceedings in which challenged ballots can be, the only thing that by law that you investigate is whether the voter was qualified to vote or not. So it doesn't, so even though yet, if you went on a precinct by precinct basis and FOIA'd or investigated every single ballot, because these records are not kept, and you sat there and flipped through how many millions of ballots are cast in Michigan on a precinct by precinct level, you could identify them. But under the law, there's nothing really you can do with that. There is no legal mechanism for, in the context of a recount or the context of anything other than a contested congressional election, for doing anything with that. And the only thing you can do is to determine whether that voter was qualified to vote, which again doesn't get to the problem of when you have an envelope and a number that doesn't match, there are two voters affected, and counting that ballot as challenged only automatically disenfranchises one of them.
And millions of voters, and we're talking about like 30 exemplars that were identified in highly populated areas. What is,
I have no idea whether that's representative or not, and I'm not trying to dodge.
I thought you cited the chart.
I-
Did you not cite the chart in your brief?
We did cite the chart and
Okay, so is it a valid chart or not?
it is a valid chart of the 144 poll books that they looked at. What I was saying is I can't say if those 144 poll books are statistically representative of what would happen statewide.
Council, you have about a minute and a half left. And one thing I don't know if you fully addressed is whether this permanent injunction was necessary.
I think it was necessary. It's necessary. There isn't a procedure on December 3rd, or whenever the, Court of Claims order came down, there wasn't a procedure for dealing with this. We needed a procedure, and the permanent injunction provides a procedure in place until the Secretary of State promulgates rules. She hasn't done that. I don't know why. But it's only in place until she adopts her own procedure. That's, I think, a flexibility that hasn't quite been recognized. But I guess to speed talk through my last 30 seconds or so, MCL 168-768 is not silent. Under the plain language of the statute, the negative implication canon, and the language of the other statutes, including MCL 168-765A, that says AV ballots should be processed just as nearly as possible as in-person ballots. So that hooks in 797A. So under all of those reasons, MCL 168-768 does the plain meaning of that statute is that ballots with missing or mismatched stub, to quote the Court of Claims, cannot by law be tabulated. While we think the court did not, if you permit me 15 seconds, the court did not abuse its discretion with respect to the permanent injunction. We would encourage, if you have concerns at it, to send it back to the Court of Claims for further proceedings on the specific aspects that you feel are you decide are problematic. Thank you very much.
Thank you very much, Counselor. You have 5 minutes and 44 seconds in rebuttal.
I do want to take a moment here just to correct myself earlier. As council pointed out, I said 115 precincts. That's not right. It was 144 poll books. But again, that still was reflective of thousands of voters, and it included regions like Macomb County, Oakland County, and Wayne County. And specifically in Macomb County, out of 19 poll books, there were 4 missing stubs. In Oakland County, out of 23 poll books, there was 1 missing stub. And in Wayne County, out of 18 poll books, there was 1 mismatch. To address something that Brother Counsel mentioned about the idea that a mismatched ballot necessarily means that some other voter is disenfranchised, respectfully, I don't see why I don't think that's necessarily true. A mismatch can arise when family members jumble their ballots when they're voting at home. My ballot goes in my wife's ballot goes in my envelope. No one's been disenfranchised. Both of our votes have been sent to the clerk for tabulation.
Also, can you address the argument regarding the language being negatory if we count those ballots?
I was following along. I want to be very clear. The 2024 amendment also added each ballot must be inserted in the tabulator language. So if we say that the statute was amended to include the if language, you can't read if in isolation. That statute was also amended after the Constitution was amended to add new voting rights, notably amongst them the right to vote in an absent ballot and the right to prove your identity by signature. So the amendment here was not to invent this new process to verify voter identity. It was to comply with the constitutional requirement that every citizen has the right now to vote in an absent ballot and to prove their identity via signature. I would also point out that the plaintiff's argument here is relying on an inference, this negative inference. I'm not aware of any other circumstance where a constitutional right, in this case, the constitutional right to vote and vote by an absent ballot, can be denied on the basis of an inference. I would want that to be absolutely explicit. You would expect that the legislature would make that very plain. They simply have not done so here. And lastly, one other thing, council talked about the secretary, why we haven't promulgated rules. One of the problems we have is we're not entirely sure that promulgation ought to be required as the injunction requires it to be. There are other things the secretary can do, issue instructions, issue guidance. Not everything has to be promulgated as rule. With that, I have nothing else unless the court has additional questions for me.
No further questions. Thank you very much. Counselor,
Thank you.
this
This-
matter's been submitted.
This was thrilling. Thank
Yes.
you. This is what democracy is about. So I appreciate the exchange and the wonderful briefing as well as advocacy here today. Thank you all for that.
I would echo that. Thank you.
Well, he's learning from a U of Mer, so you know. Yeah. I know, I know, that's why I said that. I said you're having to take his, carry his box for him and learn. Just giving you a hard time.
All right, we're going to call item number 2, listed on the docket number 374554, People of the State of Michigan versus Darren Leonarda Thurman. We have one person endorsed. Mr. Clements, you have 15 minutes. Thank you.
May it please the court, Your Honor. Good morning to this honorable panel. Very pleased to be here, Judge Bozzi. Good to see you again. I don't really have an extensive presentation on behalf of Mr. Thurman. What I would ask Your Honors to consider in this particular case is that these are various counts of criminal sexual conduct, obviously a very serious matter in which a child alleges that they were victimized by the defendant. When I look at the very brief transcript in this particular case, it's difficult for me as what I consider myself now to be an experienced defense attorney who's tried a litany or a wide variety of cases where individuals are charged with heinous crimes. It's difficult for me to recognize what the strategic play was in terms of being able to defend Mr. Thurman in this particular case. And I say that because I look at the cross-examination that was employed by Mr. Gagniak, a defense counsel in this particular case, and it almost seems as if it's a re-verification of what the complainant testified to in direct examination. And that does happen from time to time as a defense attorney. Sometimes there's, for lack of a better term, there's just not a lot there for you to be able to either attack the credibility of the complainant or to be able to show that there's a possibility that the information that's being provided is just not truthful. But when that happens, we have to ask ourselves on the defense side, what's the counter approach to being able to defend our client? And in this particular case, we have 3 witnesses that were called, no witnesses that were called by the defense. It's alleged that this young lady was assaulted, sexually assaulted in a home while there were other adults present, and those adults also did not testify. So when I ask myself what could have been the strategy to be able to defend Mr. Thurman, I'm left with one conclusion, is that it was basically a hope and a prayer. And that's not what advocacy is. That's not what criminal defense is. And honing in specifically on the utilization of an expert, we know that you can't bring in an expert to say, sir, madam, is this particular complainant lying? Are they being untruthful? That's not how you utilize an expert. What you do is examine the adolescent, examine the youth, ask them about how this traumatic event, how it changed them, and then examine others that have observed them to ask whether or not they've seen behaviors that are consistent with that pattern, and then ask the expert specifically when a child, an adolescent, a teenager has suffered a traumatic sexual experience, what change do they typically exhibit during your treatment, during your practice? And that's how you effectively utilize an expert. And it is effective to the extent that it allows you to then compare what the expert says or tells a jury that we noticed from a medical science perspective. And these things are tested, tried and true, that when a child or an adolescent suffers sexual traumatic abuse, that they will exhibit these traits, these symptoms. You'll notice these changes in their character. And then you ask the witnesses that have day-to-day interaction with this young person, do you notice these things? That's the appropriate way to cast doubt on credibility when you aren't able to make headway with a complaining witness when they testify. I mean, sometimes on the defense side, we don't always get to impeach. It's great when you do, but I don't believe that there was a single point of impeachment. There were some inconsistencies, but being slightly off on a minor detail and impeaching on a significant detail are 2 different things. You might not even get the impeachment instruction as trial counsel when it's just on a minor inconsistency.
I'm glad you explained that, counsel, because as I reviewed the brief and was preparing for today, I couldn't help but think that the argument regarding an expert for purposes of challenging credibility would in and of itself be ineffective assistance of counsel because of the Thorpe claim.
Yes.
So I appreciate that analysis because that threw me like, that's a sure way of getting, a claim for ineffective assistance of counsel.
Sure. And I would, and again, the reason why I'm forced to take the approach is because of the brevity of the trial, the way the examination was conducted, and how the question and answer came off. If I'm just forced to evaluate the testimony candidly, and I won't repeat the young lady's name, but there's not a particular point in time where I can look at this and say, okay, there's the aha moment. There's where I can focus in on and be able to say strategically, this particular portion of the testimony is where an aggressive or an assertive defense attorney should be locking in to try to create reasonable doubt or to establish reasonable doubt. And to me, that did not happen because I don't see a strategic plan in order to be able to extract doubt or to be able to create a record as such, giving Mr. Thurman an opportunity to be acquitted by the jury. He doesn't testify. There's no character witnesses called on his behalf. I've already honed in on the fact that there's no expert testimony. So really, this was just a reaffirmation. We don't even get.
But we don't know what any of them said. We don't know if defense counsel interviewed the people in the home, for example. Do we know that? Like, did the defense counsel interview grandma who was supposedly there, and did she have anything to say that would have been helpful?
I don't know the answer to that.
We don't either.
But I would say in response to that, though, is that at the end of the day, the prosecution does have the burden of proof in terms of providing credible evidence. And if so, when I look at Mr. Wheeler and the presentation of his case and the witnesses that he did choose to present, to me, if these individuals that were in the house had helpful testimony to be able to provide, the prosecution certainly would have called them. And on the defense side,
Grandma didn't know.
so, and I guess if the defense is to be able to say, Justice, that this did not happen, right? That this was a fabrication. If that's the defense strategy, then to me, any witness that's in the house that can say she never recognized a particular point in time where the complainant was in the basement for a sustained period of time is helpful to the defendant.
I thought we had some testimony that she's like spent a lot of time in her room because of.
That is true, but also she was directed specifically not to go in the basement, and she acknowledges. Oh yes, that fair enough. But I still believe that nonetheless, if an examination to the extent about whether or not she even had any knowledge to that effect is something that should have been explored, we should have the testimony on the record. And I'm saying from the defense perspective, the failure to do so is unacceptable, given the entire ingredients that were utilized for purposes of trying to create reasonable doubt or to highlight reasonable doubt on behalf of the defendant.
But I guess the issue is we don't know if it wasn't done. We don't know if defense counsel didn't interview those witnesses and then ultimately didn't decide to take their testimony. We don't know if their testimony would have been favorable to the defense. We don't know any of that. We're just assuming that he didn't and assuming it would have been favorable.
And I don't dispute that, Justice Bazzi, but what I would say, Judge Bazzi, is that, again, taking the issues together in combination is what we're levying on behalf of Mr. Thurman from an appellate perspective. Is the fact that we don't have that information from the witnesses, we don't have an expert, and he doesn't testify collectively, and there's no character witness. So if we blend all that together, then it starts with the same question that I'm presenting on behalf of Mr. Thurman to be able to say that this trial on behalf of him that was really done in basically a couple of hours. I mean, we got started on December the 4th at about 9:30 in the morning, and closing arguments were concluded at 3:50 in the afternoon the same day. So I at least should be able to recognize what is the strategic aspect that's being, or the strategic argument that's being advantaged on behalf of Mr. Thurman to give him the opportunity to be acquitted. And I simply can't extract it here. And when I come to that conclusion, I believe that his counsel was ineffective, Your Honor. If there are no other questions, I'll conclude at this time.
No other questions?
Thank you very
you.
much, Counselor.
Good to see you.
Nice to see you as well. This matter has been submitted. Turning to item number 3, docket number 372230, People of the State of Michigan versus Joseph Robert Berkelbaugh. Here today, we have just, oh, we have one remote. Okay.
Panel. Mr. Strauss is not currently in the gallery.
Okay, so it looks like we do not have Mr. Strauss. We have counsel for appellee. If you want, you have, I guess without opposing counsel, you have 15 minutes.
Good morning, Your Honors. Matt Fillmore from the Oakland County Prosecutors on behalf of the people. I had an argument prepared, but I guess there's no oral argument to respond to. So I will rest on my brief, and ask the panel if they have any questions.
All right, thank you very much,
All right.
Counselor.
Thank you.
Thank you.
This matter has been submitted. Turning to item number 4, docket number 371015, People of the State of Michigan versus Hammond Lorenzo Dixon. Good morning, Counselor. How much time would you like for rebuttal?
Your Honor, good morning. Nice to see you, Judge Bazzi. I would like to reserve 4 minutes for rebuttal, and I will try to keep track of my own time as well, Judge. Stephanie Farkas appearing on behalf of Hameen Dixon. I work with the State Appellate Defender Office and the Private Counsel Division at Max. And Your Honors, this case essentially boils down to the trial court committing errors that resulted in the denial of Mr. Dixon's right to appellate review and the right to appointment of appellate counsel. I want to start off by kind of hitting a few points for the court in terms of MCR 6.428, because there have been several iterations of that rule that have been enacted by the Michigan Supreme Court. And most recently, I wanted to highlight the change that occurred in September of 2005, while this case obviously has been pending before this court, but after we submitted briefing in this case. So the version that was enacted, and actually let me back up a little bit. So the very first version of MCR 6.428 was adopted in July of 2005. So that first version was adopted after Mr. Dixon's conviction in this case. And that first version of the rule required essentially ineffective assistance and deficient performance from counsel for a trial case with a claim of appeal. It did not include any sort of relief for anyone who pled guilty. Then in 2021, effective in January, we have an amended version of 6.428, which is the version that Mr. Dixon relied on initially when he filed his pro per pleading in the trial court. He filed the pro per application with this court, and then the court granted the application, and I subsequently was appointed. And so that was the version that Mr. Dixon relied on, and we're essentially relying on as well, where it expanded out to guilty pleas. And I'm sure the court obviously, hopefully, is aware of all this from staff, but I just wanted to highlight it in my argument. And that it expanded out the different scenarios in which the rule could be applied, including errors by the court, errors by counsel, and factors outside the defendant's control. And then the September 25 version of 6.428 added the primary substance of the rule, the first section, remained the same, but it added some additional requirements regarding filing the motion within a reasonable time. And then it added some presumptive circumstances in which it would be deemed reasonably filed under the time standard within 2 years of the entry of the judgment of sentence, or the denial of counsel essentially would be the provisions that would be applicable in this case. And so I know my briefing highlights how the 2001 version would be applicable, and I'll rely on my briefing generally for that. But I also wanted to highlight that if the court decides to apply the newest version, I also think that Mr. Dixon would be entitled to relief because of subsection, I believe it was E, that also states that in determining reasonable time under the rule, the court must consider whether there's factors existed outside the defendant's control that contributed to the delay of the filing. And so in this case, because of the timing of the statute and relief not being available to Mr. Dixon until 2021, that accounts for a huge amount of the delay in him filing the case or the motion. And then subsequently this rule, but also I do want to note too that the Reitmeyer test would also, I think, dictate that the 2001 version essentially should be controlling, because if for some reason that the court does not find that there's any sort of factors outside of Mr. Dixon's control under the newest version, then the Reitmeyer test essentially provides that when someone relies on the applicable version of the rule at the time the case is pending by either failing or through inaction or action, then you should not apply the prospective rule as required under 1.102. So in this case, Mr. Dixon filed his motion relying on Byers and Tardy, which explicitly do the analysis for the 21 version of 6.428, and then also indicate, that there's no time frame. That version of the rule has absolutely no time frame that anybody is required to file anything. And given the newness of the amendments in 21 and the timing of when Mr. Dixon actually filed his pleadings, you can tell that he clearly is relying on that case law and the reasoning that there is actually no timing requirement in that version of the rule. And just to kind of highlight a little bit more of the timeline, because I had to kind of do this in my head in preparing again. Mr. Dixon was sentenced in October 2004. First version of 6.428 comes out in July 2005. Then we have Halbert that's decided by SCOTUS in June of 2005. I'm sorry, yeah, in June 2005. We have the letter from the Circuit Court Administrator's Office that gets mailed out to Mr. Dixon in July of 2005. And then, subsequently, his motion for relief from judgment in 2012, the second version of 6.428 in January of 21. We have Byers and Tardy that comes out in 2023. Mr. Dixon files his pro per motion in the trial court in April of 24. We have the denial from the trial court in May of 24, and then Mr. Dixon's initial pro per application to this court in May of 24. So the timeline is kind of consistent in terms of him relying on the 2021 version of 6.428. And I want to also highlight in terms of the trial court's complete and utter failure to comply with the court rules and the statute that was in effect at the time, and advise Mr. Dixon of his appellate rights. And there's absolutely no reference to anything regarding appellate rights in the sentencing transcript. So it's very, very, very clear. And I think, by the plain language of 6.428, in terms of the language, including or, that there is the option to have multiple circumstances for application of restoration of appellate rights. There's an error of the trial court that denied appellate review or the appointment of appellate counsel. And the fact that the court failed to do any of this, I think, is very indicative and controlling in terms of it being an error by the court and a factor outside of Mr. Dixon's control. And in terms of bolstering Mr. Dixon's credibility regarding the 6.428 claim, in his motion for relief from judgment that he filed in 2012, in his affidavit, he talks about how he actually did receive those forms from the court, filled them out and returned them, but then nothing came of it. And he thought that there wasn't anything granted or there, you know, there just wasn't anything for him. So that was, you know, 12 years before he filed on the motion for restoration of appellate rights. So I think this case is a perfect situation where the intent of the rule should be applied and Mr. Dixon should be entitled to restoration of his appellate rights. And I just wanted to highlight one more thing from this court and try to respond to Sister Counsel's briefing, in which she talks about how the appellate courts have already decided the merits of Mr. Dixon's issues. And he has raised, you know, various issues in the motion for relief from judgment that was filed in 2012. And the failure of the court to advise of his appellate rights was part of some of those issues, but more so part of his explanation regarding the procedural bars of 6.502. And the order from the Court of Appeals in that case actually specifically cites that he did not essentially meet the burden under under the 6,500 procedural rules. And it wasn't necessarily on the merits that he raised in the appeal. It was the procedural requirements for filing the 6,500. And I want to highlight how there's a big distinction between your rights on direct appeal and what you have to file for a 6,500. And so I think Sister Counsel misconstrues that in her brief, and I wanted to highlight that for the court. And unless you have any other questions, I'll
Thank you
save
very
the rest of
much,
my time
Counselor.
for rebuttal. Thank you.
Good morning, Your Honors. Ashley Stone from the St. Clair County Prosecutor's Office on behalf of the people. I think ultimately our question on appeal here, right, is did the trial court err in denying defendant's 2024 motion to restore his appellate rights under MCR 6.428? I agree with the defendant appellant that the 2021 version of MCR 6.428 would apply. And that rule, right, really says that if the defendant lost the right to appellate review through an error of the trial court or of his attorney and through no fault of his own, then his rights should be restored. And so when I think trying to address that question, you know, posed by the rule is when we need to look at the trial court's obligations from 2004, what he needed to be advised in terms of his appellate rights then, and what other information he might have known around the time of his sentencing, which is what this court asked us to address in granting the application in this case. So I agree, in 2004, the trial court was supposed to advise defendant that he could file an application for leave to appeal, but that he did not have the direct right of appeal, and that they should have advised him that appellate counsel could be appointed if he met various factors. And at sentencing, there was a MCOA form that should have been provided, and none of that was done by the trial court in 2004. I think that's clear from the record. It just wasn't done. I disagree, I think, a little bit, as discussed in defendant's brief, about Halbert sort of interveningly then imposing another burden for them to tell you, well, now we have to appoint appellate counsel, and that the trial court maybe should have gone back post-sentencing and informed defendant of that. I don't agree with that. But in addressing sort of the second part of what the court asked us to, what did defendant know at the time of the sentencing, at the time of his sort of post-sentencing an active appellate period, I think it is important to highlight that his father, acting on his behalf, went to the St. Clair County Circuit Court, asked for the forms that he hadn't been given, asked for the form to be appointed appellate counsel, and was given them. And we know from the defendant's own affidavits or assertions that he did receive those forms, that he filled those forms out. He says he mailed them back. We also know, based on the defendant's sort of other history when we look at him, that he had been through the criminal justice process before, that he had actually engaged in an application for leave to appeal prior to this case. So
I'm going to stop you for a second. What does that matter? I mean, he says that it appears that it was accepted that he filled out those forms and sent them back. And so the presumption is there was an error. That wasn't his fault that those forms weren't received and he wasn't appointed counsel. So what does it matter that he he'd been through the criminal justice system before and he should have known the process. It appears that he did what he was supposed to do. They requested the forms, they received the forms, he filled out the forms, he sent them out, but he didn't get the response he should have gotten from the court. And so why should anything else matter, I
Right,
suppose?
I think it matters, Your Honor, because I think that the defendant essentially abandoned his pursuit of the appeal.
Well, did he
12
abandon it or did he not, did the court not process that paperwork as he should have? Maybe, I mean, just because somebody's been through the criminal justice system once before, twice before, even 5 times before, it doesn't necessarily mean that they understand everything that is occurring as it's occurring. And so so how do you jump to the conclusion that he abandoned the appeal when he sent the forms out, didn't hear back? And are we supposed to assume that he then is going to, because he didn't hear back, he abandoned it, maybe for other reasons, he just didn't believe he could pursue it?
So I guess, Your Honor, I would say that I look at the facts that we have on the record and interpret them differently. I think it matters because I think 7 years, what we know is that 7 years elapsed between the time that he requested the form and the forms and the next time that we hear from defendant. I'm sorry, I mean, I guess I
It's
do.
important. I'm thinking what she's thinking, so I need the answer.
I'm sorry, I'm trying to answer. Maybe I'm misunderstanding. I think the fact that 7 years elapses from the time that defendant gets the forms, we know that happens, and the next time we hear from him, I think that that time frame suggests abandonment. I think the fact that he had previously experienced an application period would suggest he had some knowledge to maybe say, I should follow up in the 7 years. I should inquire. I should go back to the court. Something's gone awry here. Does that answer the
So
question?
we're supposed to take, so the court makes multiple mistakes in sentencing, right? And failing to provide him with the information that is required in order for him to make an appeal. And then the court doesn't process paperwork for the appeal, but then we're supposed to shift the burden now onto a person who's currently incarcerated with very minimal resources versus the entire system that just failed all of these things to follow court rules.
I don't think that's what I'm suggesting, and I guess I maybe want to correct one of those premises in that train of thought is that we know the defendant was given the forms. I don't know that he filled them out and sent them back to the court. That's the defendant has provided that in an affidavit. If we accept that statement, then we know that. But none of us otherwise independently know that he in fact completed the forms, that he sent them to the court, or what
Didn't-
happened thereafter. I don't know that based on the record. I know that only on the defendant's own statements that he's presented.
Well, didn't the trial court seem to accept that? And please correct me if I'm wrong, but didn't the trial court seem to accept that the defendant did in fact return or accept that affidavit, and, questions of credibility are left for the trial court? So it appears that the trial court seemed to accept that these forms were sent back, but
See, my understanding
for
is
a different reason, that he wasn't, for other reasons, appellate rights should not be restored.
so in my understanding and my reading of it is that the trial court accepted that the forms were provided, that he had received the forms. I guess I won't speak to whether or not we're all accepting that they were in fact filled out and returned. But even if we do, I do think that the time that elapses between the request for appellate counsel for receiving the appropriate forms and the next time that defendant makes any efforts to pursue his appeal, I do think that that time matters. I think
Maybe he's a lay person and just doesn't know the timing. I mean,
and that's where I would point to his previous, I guess,
Okay.
experience to maybe push back against that assumption, that he just
okay.
doesn't understand the timing.
Are you really though, counsel, suggesting that he needs to raise his hand again? He did everything he was supposed to do. If we accept his affidavit, I understand you may not, but on the other hand, you have brought no evidence to suggest otherwise.
I don't remember a contrary affidavit.
None.
Did I miss that correctly?
No, I
None.
don't, we don't, Your Honor. We have the defendant's own statements about what his experience was, and we have I think that's it. We have a void in terms of what happens after he requests those forms in 2005. We have a void until 2012 when he files the initial $6,500.
And he has to dispatch his dad. Because again, the court failed.
And if the court made all those mistakes at the front end, he did see, why should I give the court this option? In case of no alternative application.
But like I said, it was in looking at what MCR 6.428 requires. Did the trial court err? Does the attorney err? Was there no other fault of the defendant? Trial court erred. I won't dispute that. That's clear on the record, right? I think none of us would be standing here had the advice been given as it was supposed to at the time. In terms of what MCR 6.428 otherwise said, did he lose his right to appeal through no other fault of his own? It's the people's position that Mr. Dixon sort of what I would characterize as the abandonment or lack of follow-up for several years, despite otherwise having the forums, despite otherwise having information given to him, suggests that he abandoned or chose not to pursue his appeal at that time, and that restoration wouldn't have been appropriate so that the trial court didn't err. If this court obviously disagrees and feels that that 7-year lapse in time and is too much or is burden shifting onto Mr. Dixon,
How about
this court can do that.
How about if we characterize it as the system failed him for 7 years? He had lost his liberty, spend one night in a jail cell, and tell me it isn't a wretched experience. The system failed him after 7 years. This is not on him.
Understood. I understand the court's position, Your Honor. I did also in my brief raise the idea that he had not been denied appellate review because there was subsequent review of some of his claims. I think counsel for defendant appellant has sort of pushed back against that. I'll rest on the argument that I've made sort of in my briefs as to that point. With that, Your Honor, I have nothing else. I would conclude unless there are any other questions I can answer for this court.
No further questions. Thank you very much, ma'am.
Thank you, Your Honor.
All right, any rebuttal?
Very brief, given the court's comments, but I just also wanted to highlight for the court and buyers, in terms of the denial of an appellate right or right to appellate counsel. In the buyer's case, the court specifically even held that even if someone is appointed counsel, there could still be a denial of a right. And so sister counsel talks about, the burden being placed on Mr. Dixon, and, that this court has talked about the trial court's failures. But I also wanted to highlight that, even if there was something done, because in the buyer's case, the defendant in that case actually filed a pro per motion for new trial on their own. And counsel that was subsequently appointed failed to act on that. And then the court still granted relief under 6.428. So I think that case is somewhat indicative. If the court, it doesn't sound like the court is holding any burden against Mr. Dixon, and rather relying on the court's or the trial court's errors. But I just wanted to point that out for the court as well. So, and I would
Sato is well familiar with the problems with getting mail out of the prison system.
and Your Honors, I can, I'm on the max end, and so I can attest that, I think there was not long after I first joined Max, there was a slew of cases out of Saginaw County where I got appointed because there was a stack of requests for counsel that were just found in the court that were all untimely, where I had to do restoration of appellate rights. And so these things happen all the time, all across the state in various courts. And I know that's outside of the record in this case, but I think the record in this case is very clear in terms of the errors of the court. So I would ask the court to reverse the trial court's decision and grant Mr. Dixon relief under 6.428 and restore his appellate rights. Thank you.
Very much. Any further questions? Thank you. This matter will be submitted.
Thank you.
Moving on to item number 5, docket number 372113, people of the state of Michigan versus Anthony Keith Reyes.
Good morning, Your Honors. Henry Schneider from the State Appellate Defender Office, appearing on behalf of Mr. Anthony Reyes. And,
How much time would you like for rebuttal, Counselor?
Could I reserve 4 minutes, please?
4 minutes? Oh.
Thank you. To start, I intend to focus my time today on the sufficiency issue, the expert issues, and the Fourth Amendment issues in Mr. Reyes' case. First, the evidence, even viewed in the light most favorable to the prosecution, fails to establish the elements for maintaining a drug house as Mr. Reyes was charged with doing. As you're aware, wasn't really an allegation that Mr. Reyes or his girlfriend, wife now, were using the car to use drugs. The allegation was that they were using the car to keep and or sell drugs. But the Michigan Supreme Court's holding in Thompson, which adopts Georgia Supreme Court's test, indicates that incidental use of a car or building for those purposes is not satisfactory. With respect to selling, the allegation or the prosecutor's argument with respect to selling was that Ms. Dots, Mr. Reyes' wife, gave testimony indicating that she was aware of a single transaction having occurred while they were staying at the Baymont that she was not a witness to. And even if that were true, it would still be a single instance and thus incidental and not satisfactory for the statute. With respect to the allegation that they were keeping the car as a drug house or using it to store drugs, the prosecutor points to portions of Ms. Dott's testimony where she kind of gives some unclear testimony about their use of meth while they were staying at the Baymont, that Mr. Reyes may have brought the meth in the safe into their hotel room for them to use and then return the safe to the car. But I think that I would like to draw the court's attention to this particular issue because this testimony gets clarified later on. And it's important to bear in mind that Ms. Dotz also testified that her memory of those days wasn't exactly clear and that she was uncomfortable on the stand testifying against Mr. Reyes. And so the court did have to step in on a couple occasions to clarify her answers. And with one of them, the court asks Ms. Dotz, on what day in relation to the raid, which occurred on September 6th, did Mr. Reyes bring the safe into the hotel room? Ms. Dotz answered the day before the raid, September 5th. Later, the prosecutor went on to ask a bit more about September 5th and their use of the meth within the hotel room on that date. And the prosecutor went on to ask Ms. Dotz, then where did the safe go after that? Speaking about using meth on the 5th, where did the safe go after that? Ms. Dotz testified very clearly, when we left the hotel and went back to the car. And so I would argue that Ms. Dott's testimony indicates that their practice or their intention was to store the safe and the meth within it in the hotel room when they had a hotel room secured. The night of September 6th, they didn't have a reservation. They needed to leave the hotel, and so the safe left with them. And taken together, at most, Ms. Dott's testimony gave rise to an indication that this car may have incidentally been used to store or sell drugs, but that is not satisfactory to satisfy the maintaining a drug house statute.
What about the scale, the packing material, that all found in the safe?
Well, the scale for one was also found in the safe. The drugs were, with the additional meth was found in the safe. I believe Ms. Dott's testimony indicates that all of that was brought in together when they wanted to use meth inside of the hotel room when they had a reservation, and that's where it was kept when they had a reservation. And so well, the existence of the scale and the separate storage also feeds into the expert issue I'd like to discuss a little bit later, but I don't really think that the presence of the scale or separate packaging within the safe makes a difference for the maintaining a drug house issue. Because the prosecutor's allegation was that they would bring the safe into the hotel room specifically to use meth. When they were finished, they would return it to the car, and thus it was being stored there.
But so they're homeless, right?
At this point in time, yes.
And they're traveling. they're on their way, I think, to visit a grandchild or something of the wife, correct?
Well, Miss Stotts had been staying with her daughter, but was no longer welcome at that property. And she had picked up Mr. Reyes from the airport, and their intention was to get out of the state again as soon as possible.
And they don't have any money.
Mhm.
And we have at least one instance of them raising money. This is the testimony of Duns
Mhm.
by selling from the farm.
Mhm.
So, I mean, all the inferences are supposed to go to the prosecution. Why isn't there enough there?
Because I think taken completely as true, we're still only describing a single incidental instance, which is,
Circumstantial evidence to the contrary, because of its pattern. The scale, and that's why the scale matters. That's why the packaging matters. And the amount of meth matters.
sure, and I would love to talk about that a little bit later in more thorough detail. But I would argue that even taken completely as true, Ms. Stott's testimony amounts to a single instance of the car being used to store the drugs and a single instance of the car being used to sell drugs. And thus, I don't think that establishes the elements of maintaining a drug house.
Well, that seems more than incidental, though. They used the car to sell drugs on at least one occasion. That seems more than incidental.
Well,
Like, it's not just transporting, right, to get from point A to point B.
well, I think that's all that was testified to. And I think for the court to infer additional sales or additional instances of the car being used to store drugs is inappropriate for the purposes of the maintaining a drug house statute in particular. It was. The jury did, but they should not have been given the opportunity. I think the question should never reach the jury.
I understand.
Thank you. And moving on from that, trial counsel was ineffective for Mr. Reyes for failing to cite to the correct authority while objecting to Officer Stocker's qualification as an expert in this case, and was further ineffective for failing to put on a counter expert. Under Kowalski, expert's opinion needs to be reliable. To be reliable, it needs to be based on a foundation of scientific data, principles, and methodologies. And the data, principles, and methodologies described in the process of qualifying Officer Stocker was circular, self-substantiating, and irrefutable. The problem is how do we know, or how does the jury know that possession of more than 1 gram of meth indicates intention to distribute? Because Officer Stocker says so. How does Officer Stocker know? Because of his interactions he describes with drug dealers, drug users, informants, through his investigations and controlled buys. How do we know those sources are reliable? Because Officer Stocker says so and assures us that these sources are honest. Does Officer Stocker keep any records, or anyone in his drug task force keep records that would help anybody substantiate what he's saying? No. And he says that it could be done in a way that would safeguard the identities of those people. And the main problem with this is that no one gets to peer behind that veil. As I said, that testimony is irrefutable. And thus, Officer Stocker should not have been qualified as an expert in the first place. But if his experience is enough to satisfy the requirements to be qualified as an expert, the expert we proposed, Mr. Jeremy Hades, certainly would as well. He was a user for many years, he's been clean for many years, and he works with people who are currently addicted. And his trial counsel was obviously aware that the amount of drugs, the presence of the scale and multiple storage locations were likely to be used to suggest to the jury that Mr. Reyes intended not just to possess, but to distribute. And aside from cross-examination, without a counter expert, Officer Stocker's irrefutable testimony about 1 gram or more than 1 gram indicating seller presence of a scale indicating seller, presence of multiple storage locations indicating seller, the jury wouldn't have anything conflicting with that or combating that. Whereas an alternative expert or a different expert could have cast some of those issues into doubt. The fact that possessing more than 1 gram does not necessarily mean that somebody is selling rather than using. The presence of a scale doesn't necessarily mean that either, and that people often keep different quantities in different locations so that if they are the victim of a robbery or a theft, they won't lose it all at once. But as trial went, Officer Stocker's testimony on those points went irrefuted. Finally, I want to briefly discuss the Fourth Amendment issues in Mr. Reyes' case. Thank you. Just a moment, please. The police violated Mr. Reyes' rights by basically targeting him for investigation and ignoring his right to privacy and the contents of the locked safe in this trunk. When police moved to arrest, or when the police moved to investigate Mr. Reyes, they had not witnessed him engage in any suspicious activity at all that they managed to articulate. They were at a hotel that caters to low-income people. The officer daily testified to preliminary examination that they observed Mr. Reyes walk from his car to the hotel lobby and back to his car twice. How that is distinguishable from innocuous hotel patron behavior anywhere is unclear, and I don't think that it is. Undercover officers in the hotel lobby overheard Mr. Reyes' name as he gave it to the hotel concierge. That led them to investigate him on Facebook, find his name, run him through lean, and determine that he had an Idaho in-state pickup only, non-extraditable warrant. And while none of those individual actions on the part of police may have violated his reasonable expectation of privacy, and I would argue that they would, the aggregate impact of the police's activity with respect to Mr. Reyes violated a sense of privacy that people would generally find to be reasonable. Well, part of the issue is, well, anybody could, but these were state actors, of course, and I think the court should at least take a close look at the fact that Officer Stocker, or I'm not sure if it was Officer Stocker, I shouldn't say that, but somebody indicated that they heard Mr. Reyes' name and they said, based on a name like that, we decided to investigate further. Or based on a name like Anthony Reyes, we decided to investigate further.
I think there's more than one way to read that. I read that part. The transcripts. I thought they were saying based on the fact that they heard it public.
And I think that's a different interpretation, and I would note that the trial court completely failed to engage with our interpretation of that statement. I would ask this court to at least consider it.
Well, if you have something else, like just standing on its own, when you have two possible interpretations, to go to that one, I think I would need more.
Sure. Well, that fact in and of itself, looking up his name that he stated in the hotel lobby, that does not violate his reasonable expectation of privacy. That combined with the decision to investigate him baselessly, just for being in a high crime area, that combined with the decision to investigate him at that point and some of the other factors violated his privacy. Beyond that, no one consented to the police going into unlocking and searching the safe found in the back of the car. Mr. Reyes was arrested nearby. Mr. Reyes did indicate to police when after Miranda that he they would find a small amount of meth balled up in a t-shirt under the front seats of the car. But that container is a separate unit for Fourth Amendment purposes. Even if police had probable cause to search the trunk, it did not extend to the lock safe. Mr. Reyes did make a comment to the police that they could go ahead and search, but that followed an exchange relating to the luggage in the back seats of the car. That consent extended to the passenger compartment.
Yeah, so I watched that video a couple.
Mhm.
Yeah, I thought he was very, go ahead, search the whole car. Like, I thought he was, I could see where an officer, I'm not sure that's what he was saying. I'm not sure that's what. But it wasn't an unreasonable interpretation of what he said. Do you know what I mean? Like, if I'm the officer and I'm listening to him, he was very kind of quick and cavalier about it.
Understood. And Mr. Reyes, was being, he was speaking with the officers freely, and I argue that statement was with respect to the luggage in the back seat only. But another thing I would like the court to at least examine is the fact that we don't know how this safe got open. That's not really addressed in the trial record. It's not addressed really at any point.
I was wondering that.
Yeah.
How the
because-
safe got opened?
Yes, in the video, it's very clearly locked, and Ms. Stott's testimony indicated that it's a safe that cannot close completely unless it is locked and the key is removed. When the person who received it into evidence examined its contents, it was open and unlocked, and the record never explains how that happened.
I thought about that. I was like, well, maybe it was open. Like, it's possible that that's one, I mean, it could have been locked. Somebody could have opened it. They could have gotten a key. Somebody could put the combination in. But one explanation is also that it's already. And so since we don't have anything else, that's a problem.
I would just ask you to take I don't have the precise sites in front of me, but there are a couple parts of the record and trial testimony that describe how that particular safe cannot be closed fast unless the key has been used to pull it open, and there's a mechanism that keeps it open without the key being used to engage its lock and hold it fast. I believe Ms. Dotz testified to that. I don't want to speak more speculatively than that. I think so. I think that at least the screen still from the safe in its in situ in the trunk is pretty clear that it's closed fast. But
Is that where is that? Do you know? Like which exhibit?
If you'll give me just a moment, or I can if I come back up for rebuttal, I can provide you the citation at that point. Okay. Well, beyond that, I would ask the court to grant the relief requested in our brief. Unless you have any other questions at this moment, I'll have a seat.
Thank you very much, Counselor. Rebuttal?
Good morning, Your Honors. Ashley Stone from St. Clair County Prosecutor's Office on behalf of the people. I would actually rely on our brief. I think we've addressed many of the points about sufficiency of the evidence and the claims of ineffective assistance of counsel regarding the drug profile evidence, as well as the suppression issues raised. So I would rest on my brief, but I'm happy to answer any questions that this court might have.
Any questions? No. All right, thank you very much, Counselor.
Thank you, Your Honors.
Any rebuttal?
Don't worry about the citation. I can find that. I do remember some pictures. I just need to go back and refresh my.
If I could just say, I'm certain it was provided at the very least as an exhibit in the motion for new trial in the trial court. I couldn't find you the exact citation, but it's still from the body cam looking into that trunk. It was included as an exhibit.
Thank you very much, Counselor.
Thank you.
All right, and with that, this matter will be submitted. Calling our next matter, item number 6, docket number 371692, people, or Carrie Lynn Zelinski versus Auto Owners Insurance Company.
Good morning, Your Honors. Jonathan Freshour on behalf of defendant auto owners.
Good morning,
I
Counselor.
understand Your Honors have reviewed the brief, so I will be very quick. There are.
Before you begin, would you like any time for rebuttal?
I'm so sorry, Your Honor. May I have 5 minutes?
All right.
There are really 2 issues I would like to address, and I want to get out in front of the first one and just say I understand that it's unpreserved. There was an allegation of drunk driving that came out at trial that appears to be inconsistent with the evidence as a whole. But I think what is unique about this case is the evidence that came out post-trial of how that issue really permeated both the jury and the trial court's sense of justice. The trial judge indicated that the jury was heavily impacted by the idea that the plaintiff was hit by a drunk driver, and then later indicated that the trial judge was pretty inflamed by that issue. I think that it's important only because whether or not it is true or not, it's not really relevant to the issue, which was the relatedness of plaintiff's injuries to her auto accident.
It's a hard one for me to resonate with, just because you got a split verdict on that jury. Like for me, if they were in lane, you would have gotten crushed.
I understand. Well, Your Honor, but I would actually go the other direction and say, you know, there was so much evidence in this case. And I think this really gets to the more important issue, which is the second issue, attorney fees. But it's related. I think you could say that the evidence really preponderated against a finding that there was a relatedness here, but there was a strong sense that there was an injustice done. And maybe that was the result of the split verdict. You know, I think you could go either way, if that makes sense, Your Honor, with that idea. I appreciate that. That's all I can ask. As I was saying, though, I think the bigger issue here is attorney fees, and it's related. We have a lengthy soliloquy from the trial court explaining why I believe that the trial judge felt attorney fees were warranted. And I think that is in part because of the feeling of injustice that came from the drunk driving issue, and also some negative views of defense counsel and decisions not to settle the case. But the only real issue related to attorney fees that should have been considered is whether auto owners unreasonably denied the plaintiff's claims. And as a matter of law, auto owners did not unreasonably deny benefits if a bona fide factual uncertainty existed as to whether plaintiff was entitled. That's the issue I think is really the most compelling one in this case, and I think the trial court didn't fully address it. The medical records associated with the bills in question did not suggest treatment was related to an auto accident, and they in fact refer to degenerative disease and plaintiff's medical history. And that broader medical history includes almost 20 years of related issues. And then again, Your Honor, we have a jury verdict wherein the jury was split. And I think there's an argument to say that that means that this was a close case. All of that is to say that, you know, I believe this fact pattern supports a finding that there was a bona fide factual uncertainty. There was a reason that auto owners denied this claim. And with that, I am happy to rest unless Your Honors have any questions for me.
No questions. Thank you very
Appreciate
much.
it.
Beto?
Hey, good morning, Your Honors. May it please this court, Nick Tregellis, appearing on behalf of the plaintiff appellee. I'm going to rely primarily on my briefs. I just want to make 2 points orally today. First, my opponent just said that as a matter of law, it was not an unreasonable. There was a bona fide, I say bona fide, either way, same word, there's a dispute of fact. I would submit to you that dispute was created by auto owners by their delay. When auto owners received the bills and records in spring of 2022, there was no IME, there was no opinion saying otherwise. In fact, the only thing that happened, or not the only thing, but a thing that happened shortly after April of 2022, in July of 2022, auto owners wrote to Medicare saying the neck is related only, not the rest of these conditions. And in that letter, auto owners writes, quote, "The records also outline Zelinski's injury, which arose out of the motor vehicle accident. Please note the only treatment for injury to neck, initial encounter," and she lists the CPT codes, "and injury to neck are properly related to the injury involved in this case." That was in response to a lien request from the emergency room bill that Medicare had sent. But most importantly, in July of 2022, looking prospectively at this claim, at that time, auto owners had only evidence that Ms. Zelinsky had injured her neck in the crash. Furthermore, we're all familiar with eggshell plaintiff principles. She was struck from behind in a motor vehicle accident, went to the emergency room, complaining of neck pain, was diagnosed with neck pain, and in April of 2022, received bills and records supporting neck surgery or claiming a neck surgery. And then in July of 2022, that letter to Medicare confirms auto owners recognizes the neck is related. It's not until 3 months later that Dr. Kalkanis issues an opinion. That's the only opinion that would support non-payment of the claims at issue. Again, looking prospectively, once Ms. Zelinsky has her surgery in the winter of 2022 and moving into the spring when auto owners is billed, there is only evidence to support payment of the claim. Secondly, I read a lot of medical records in this line of work, and there are many times where doctors will not write MVA in their records. Sometimes they do and sometimes they don't. They'll testify sometimes. We don't write where it came from. We write what we're treating. Importantly, these bills and records were sent to auto owners. So while the records themselves may not say MVA, the fact that the records and bills were sent to auto owners certainly suggests that the billing folks and the medical folks thought it was related. Once receiving those proofs, what did auto owners do? Did they send a letter to the treating doc and say, well, doc, it didn't say anything in your record about motor vehicle accident. Why'd you send us these bills? They didn't do that. The only thing they did was 3 months later confirm, yes, the neck is related. And then 3 months after that, they got an IME. Our law is clear. You cannot create a factual dispute by waiting on an IME report that's not yet there. In terms of the claims made at trial in this case, and I agree with what the court said, if the jury were so inflamed by these statements, which again were evidence, it weren't things I made up, just what happened. If the jury were so inflamed, I would have expected a homogeneous verdict, and it wasn't that. Why wasn't it that? Because the February 22 surgery was the neck only. The October 2023 surgery was literally the entire spine from the base of the skull to the sacrum, which, as the court's well aware from the record, the voluminous records, Ms. Zelinsky, it was a complicated medical situation with her spine. So that suggests to me that you had a considerate jury really weighing out what was related and what isn't. The neck has never really been disputed. That's why, to me, this case is always the catchphrase for me is signal through the noise. Because the signal is you have a very clear eggshell plaintiff with a neck that's very clearly related right from the start. And auto owners acknowledges it right from the start. All the rest of it is the noise. The signal is that neck and what happened to it in this accident. Dr. Ely said it's pretty obvious when I looked at it. As soon as he came into our office. And she, there's a treatment gap because of her MRSA infection, again, unrelated. So, from my standpoint, this is now 2.5 years after the trial was concluded. It was frustrating that my client had to go through what she had to go through to get to the trial. I respect that the defendant has appellate rights. Frankly, I'm glad that they're going to be exhausted soon. And I would respectfully ask that this court affirm the trial court's ruling. Thank you very much. I don't think I have anything material to add to the court beyond the briefing, except to say, from my perspective,
timekeeping wasn't contemporaneous. That seemed to be like the most hotly disputed, I think, of the issues.
That's fair, Your Honor. First of all, I would say on behalf of my brothers and sisters on the plaintiff side, as a matter of policy, it would be beyond cumbersome to have to timekeep on PIP claims contemporaneously in the hope that eventually maybe you're going to recover a 3148 fee. just as a caution, I'd say from a policy standpoint, if I was reading this opinion, I would have wanted the lawyer here to have said something about the day-to-day life of a plaintiff lawyer. It's hard to find the time to track time when so often it doesn't matter. But to the point, what does it matter that we did or did not keep contemporaneous time records? One thing I think is really important, that I think it's REETZ, R-E-E-T-Z is the name of the case that dealt with the, I might have my cases confused. Forgive me I might be wrong on the name. But the case that dealt with the timekeeping, there was no evidentiary record at all for the opponent to cross-examine the timekeeper on in that case. Contrast that with the facts in our case. Every timekeeper had a thorough spreadsheet, which is in this court's record, and an affidavit in addition to that supporting it. Now, I understand it wasn't done contemporaneously. To my understanding, there is no concrete requirement that that be done. It's a factor, and we've never concealed that factor is not contemporaneous. It's what it is. We sat down after the verdict, and every timekeeper, used a calendar, and we testified to this at length. Importantly for this court, though, what the defense had in front of the trial court was a very thorough record. And in fact, the hours were reduced based on that. There was one error in all the different timekeeping that was done, which we struck voluntarily, which was a mistake on who attended case evaluation. But beyond that, with the calendar, the register of actions available to it, the trial court, and 2 separate blocks of time on the same day, the timekeeping was thoroughly dissected. So I would say that the defense had a vigorous opportunity to question the hours, and ultimately it was then given to Judge Allen, or the trial court judge, excuse me, who used his discretion, did not abuse his discretion in awarding the amount that he did. I think that's all I have to say on it. Thank you very much, Your Honors.
Adam?
I would like to quickly touch on the idea that auto owners took too much time investigating or kind of created this error. Because I actually think that's a very interesting issue that we really need some clarification on. I was actually in front of the court last month on almost the same exact issue, a bona fide factual uncertainty in whether it existed. And I think it's the argument, very similar, I think, to what Brother Counsel brought up, was essentially that, the insurer sat on their hands. They took too long investigating this. How can they say with all this post hoc evidence that they had an uncertainty at the beginning? And there's not a lot of law explaining what an insurer is obligated to do or provide. Obviously, they're supposed to be investigating. And I think that was happening here. And for the record, Your Honor, sorry, that case I was before last month is docket number 366769. An opinion hasn't been released, but it's very related. These are complicated cases with complicated, extensive medical records, and there's an obligation for insurers to pay claims quickly when they receive them, when they have adequate proof. But at the same time, we have an expensive no-fault system, and it would not necessarily be helpful to that system if insurers truly paid every single claim that was presented to them without investigating.
But is that somewhat a watered down argument, given that apparently in your own records, you acknowledged, not you,
I understand.
but that it was acknowledged from the outset? Does that make a difference?
I'm sorry.
I get that there has to be an investigation, but when the company's own records say neck related, doesn't.
I appreciate you bringing that up, Your Honor. I am not incredibly familiar with the document counsel was referring to, although I believe it was auto owners, essentially explaining what the claim was. I don't think we're talking about estoppel or auto owners actually admitting in any way the relatedness of these. It was a statement about the claim that was being made to them. But I think the more important point is just there was clearly a long investigation, and trial established that I think some of that investigation was warranted. This case, I think, was a very close call. And with that, I'm happy to rest. I appreciate the time.
Thank you very much, Counsel.
Real quick, that was Affiliated Diagnostics of Oakland. Okay, all right, I'll take a look.
All right, this matter has been submitted.
Thank you.
Moving on to item number 7, docket number 375-270, Eugene Smith Jr. versus City of Detroit. Okay, we're gonna take well, that was the last case for our 11 a.m. docket. We will recess for about 5-10 minutes and come back out and resume with our noon docket. One moment, I appear to be having a glasses malfunction. Great, thank you for your patience during our short break. We have one item that was left over from our 10 a.m. docket. Earlier I said it was the 11 a.m. docket. My apologies for that. But from our 10 a.m. docket, and that is item number 7, docket number 375-270, Eugene Smith Jr. versus City of Detroit.
Good afternoon, Sherry White on behalf of the City of Detroit, and I'd like to thank the court for a brief recess so that I could make a phone call. I appreciate that.
Thank you. Ms. White, just a question for you. How
Sure.
long do you need for rebuttal?
3 minutes will be fine.
You may proceed.
Just very briefly, I think, I know the court's familiar with the facts and the briefs and everything. In this case, there's just indisputable that this incident did not take place where plaintiff's notice of claim stated, Wyoming and Schoolcraft. It just isn't. They further discovery, they said later, revealed that the defect may be located at Linden in Wyoming, which is a half-mile away. So there's just no way that this notice complied with the statute, MCL 691.1404 and the city therefore is entitled to summary disposition. Plaintiff has essentially conceded that the notice was insufficient. Any questions?
No, thank you.
Thank you, Counselor. Rebuttal?
Good afternoon, Your Honors. Admiral Altwheel on behalf of the plaintiff, Hallie Eugene Smith. And so realistically, this is just a municipality trying to turn a statutory provision that was meant to provide investigation and remediation and turn it into a technicality to try to dismiss a claim. The trial court correctly recognized that, Mr. Smith substantially complied with the notice requirements under the statute, which is Michigan Codified Law 691.1404. And under that statute, all that's required is that notice is provided within 120 days, along with
But it's notice of the exact location. Like that language is, and there's case law behind that. That's pretty, how do we untie our hands from that?
Well, absolutely. So they cited to a specific case called Thomas, or I apologize, not Thomas. It was a Thurman versus City of Pontiac. And in that case, the address of the defect was literally one house down. And the court dismissed plaintiff's claims because of that notice. However, there was a subsequent case in 2022, I believe. It's called Champaign versus Department of Transportation. And this was an egregious case. This was a case where a plaintiff was driving his vehicle on I-696 and a large chunk of concrete had broken off and fallen off and hit his windshield. The initial notice provided that the chunk of concrete was located near the bridge that was over Hoover Road. And so subsequent pleadings and discovery made that it was later determined that the exact location was a bridge not on Hoover, but was between Van Dyke and Mound Road. So that's more than a mile. And Sister Council literally just said that this was a half mile away from the exact location. Again, the statute 1404 specifically says that the circumstances, location, and nature of the defect must be cited, the description of the injuries, and any witnesses. There's nothing in there that says that the case will be dismissed if there is some inadequacy of the location. Another thing I'd like to point out is that in a case called a Smith v. City of Warren, the court accepted, and I believe it was this court that accepted the idea or the concept that there can be some degree of ambiguity in an aspect of a particular notice, which can be remediated by clarity of other aspects. And this is exactly what was done here.
Yeah, except the remediation in that case was done within the 90-day plan.
Exactly. So one of the things that I wanted to bring up as well, the fact that the location wasn't precise or exact in the initial notice, it was subsequently remediated. Specifically, again, one thing that a lot of these court hearings or the court holdings regarding notice under the statute, it's to provide investigation and remediation within the reasonable time period, because as public policy holds, it's the only reason the notice is required is to provide the city or the municipality, the governmental entity, enough time to go and find the specific area and fix it. And this was what was done here. And not at one point did the defendant, City of Detroit, ever contact the plaintiff. They could have asked him. They could have asked him, hey, there's something wrong with the defect. There's something wrong with the notice. We can't find what you're talking about. But another case literally said that substantial compliance is the standard. And one thing to note was that this was a 4-foot by 2-foot wide hole in the sidewalk, and plaintiff was casually walking and about to cross the intersection, and he simply tripped over it. He fell, he broke his neck, fractured his back, and this is a real injury. So regardless of the notice, the City of Detroit ended up fixing because of the notice that we provided. And another thing is, plaintiff, upon his injury, he was hospitalized for around 3 or 4 days. So I don't think the notice was something that was important at the time. It was more of recovering and getting back on his feet before he could contact counsel, make sure that he had whatever he needed done completed before he could even file a notice. So these were some of the things that need to be taken into consideration. And another thing was it happened at night. This was a general location. Plaintiff can't, I mean, one thing that a plaintiff is not going to do is like before he's getting wheeled into the ambulance, say, I'd like to take some pictures of the thing for notice purposes, because I mean, the plaintiff didn't know that was a requirement. However, it was subsequently remediated. And again, the City of Detroit, they discovered it. They fixed they patched it up, and that's really it.
Did they, just out of curiosity, did they fix it up within the notice period?
That I'm not sure, but I do know that they never contacted plaintiff. They never asked them, hey, this is not where the defect was. but we do know that it was fixed. And they're in their appeal, they're also arguing for court fees. And this was something that, kind of took plaintiff off guard, because realistically, you have a real injury, you have a real defect. The notice was provided, and defendant was never prejudiced, it was never delayed. The litigation in here, they had an opportunity to send requests to admit, requests to produce, any kind of get any kind of statement from the plaintiff, and they never really did. And plaintiff's response brief to this appeal, we're asking for the court fees, because for them to delay and harass and stall this severely injured plaintiff's right to recovery, they have never even acknowledged that he was injured. They never said, okay, yeah, we understand that you were injured, but the notice was defective, and therefore, there's something wrong there. They're simply just trying to prolong the recovery because they're a governmental entity. They have the right to delay these cases, specifically because they have the right to do so.
Counsel, I just pulled up the Champagne case, and it looks like the issue there wasn't whether the location was properly identified, but rather whether a filing of a complaint in the Court of Claims satisfies the notice provisions. Am I missing something? Because that seems entirely different than the facts and circumstances of this case, where within the notice period, there was, the city was not notified of the place.
And that's a great point to bring up. So while the notice is not something that should be treated as a pleading, that was something that I believe was cited in that case, or it might have been Plunkett versus Department of Transportation. Regardless, the fact that it was amended or it was brought in the Court of Claims, it just adds more evidence, or shows that a notice can be defective, but it can be cured through subsequent pleadings, which also, to bring up, plaintiff did in their initial disclosures provide GPS coordinates. They provided color photographs during the day. They provided irrefutable proof that there was a notice of the defect.
Yeah, I was fairly recently on a panel where I was in the minority because I agreed with you, but I believe I'm positive that the decision saying that it has to be that the verbiage, that having the wrong location on there. Yeah, I'm remembering the case that's faith to the notice itself, because it's a government entity, and therefore, they're waiving immunity, and so we have to construe that strictly. And that ties our hands. I believe that's what that case said. I'll have to go. I'm sure it's cited in the other brief, but I don't have it right on my hand.
Well, they did cite to a case where they said that a defect in the notice is fatal to the claim, and I believe it was. And forgive me here, there were some quite a few cases. I believe it was Smith v. City of Warren, or it could have been a different case. But regardless, they're arguing, the argument is that the reason that it's fatal to the claim is because it expends resources. They don't end up coming to the conclusion that, hey, we found the defect, we got all these people to come out and inspect the location, and we're wasting those resources. We couldn't find the defect, but that's not evident here in this case. The fact that they found the defect, even if it was a half a mile away, and it was again, it was remediated. They ended up fixing the defect. And in our pleadings, we also, we corrected that. And then on top of after the motion for summary disposition was denied, the trial court judge plainly stated that we're allowed to amend the pleadings to include any discrepancies in the notice. So regardless of whether the defect was fatal in the case that you're referring to or citing to, the plain language and the reason for notice is specifically to address and remediate issues. It's not a technicality. It shouldn't be treated as a hardline rule that blocks recovery from occurring. The defect was, a giant 4-foot by 2-foot wide hole in the sidewalk. Whether or not that was visible during the day, plaintiffs, under the facts and circumstances, this was happening at night. He was walking to his destination. He tripped, he fell, he was severely injured. There's no doubt about that. There should be some redressability, and it shouldn't be denied simply because the fact that the location was off by a half mile. Again, I want to cite to either Plunkett versus Department of Transportation or Champaign. One of those two cases, again, there was a giant piece of concrete that had fallen off a bridge. They were traveling on the highway. They didn't specify the exact location of the where the concrete came from, and in the notice they stated that it fell off of the bridge that was located on near Hoover Road, where in reality the real location of where that large chunk of concrete came from was between Mound Road and Van Dyke Road, which is over a mile away. So regardless, you're bringing to the attention that the government that, hey, there's something wrong. You need to go investigate. You need to go check it out. And this was done here. And this was done in those Department of Transportation cases. And essentially, they cited to that Thurman v. Pontiac, and because the address was wrong, it was subsequently overruled by, I'm not sure if it was literally overruled, but I do know that the interpretation was that in Champaign, the court literally said that no formal lawsuit would, quote, survive if the interpretation of the notice on the same standard of Thurman. So there, essentially, this hardline, strict interpretation of the notice statute, if taken literally in the context of this is going to bar plaintiff's claim, you're looking at no case that's going to ever survive that, because you have a lay plaintiff whose primary concern is the injuries that they suffered as a result of the defect, and then days later, while they're in a neck brace trying to locate the exact location. There was a general location of the area. There was a description. The notice was complicit, sufficient enough to put the city of Detroit on notice to, again, investigate and remediate. And those are the two kind of main points of notice. Similar to any constitutional notice argument, it gives the party an opportunity to be heard, along with being present at the location. So at the end of the day, we just want to affirm the lower court's decision, because the lower court got it right, that you're not supposed to have this hard line interpretation that says plaintiff's claim is barred because of some minute defect. And then as far as the court fees, the reason that we're asking for the court fees is because, again, there was a real injury, a real defect. The notice was provided. went out, investigated, they remediated the defect, and there was no subsequent prejudice to the defendant whatsoever. So for them to not be satisfied by the trial court's ruling and then furthermore appeal this case as of right, it's just adding a delay to redressing plaintiff's injuries. And so therefore, we ask the court to affirm the trial court's decision. Thank you.
Very much. Any rebuttal?
Couple of points. Judge Maldonado and Judge Rick, I think you both hit the nail on the head. The notice did not give proper identification of the location within the 120 days. The photographs that plaintiff referred to as accurate photographs were submitted during initial disclosure, way beyond that. So I think that that's very clear. Also, with regard to an amended complaint, plaintiff was allowed to file an amended complaint within 14 days of the March 31st, 2025 order. They didn't do so. We filed our appeal 3 days after that deadline had run on the 17th. So, and the fact that plaintiff is talking about injuries, I think demonstrates that, that it's very clear that this notice was insufficient and that summary disposition should have been granted. And I believe that the case should be reversed, remanded for an order granting summary disposition and a hearing on the city's request for costs and attorney fees on this. Thank you. Any other questions?
No question.
Thank you.
Thank you very much. This matter will be submitted. Turning to our 11 a.m. docket, item number 8, docket number 370968, Joshua Wright versus Brandon J. Patton.
Good afternoon again. Sherry White on behalf of the defendants.
Good afternoon. How much time would you like for rebuttal?
Good afternoon. 5 minutes. Okay, basically, in this case, plaintiff continually conflates concepts of intentional torts and gross negligence. And this case had 118, I believe it is, police officer defendants. It involved a fatal shooting of a police officer. And I think it's very clear that exigent circumstances existed for the to approach the plaintiffs. Gross negligence, there's no evidence establishing the elements of gross negligence. Again, they're conflating that with intentional torts and good faith immunity under Odom. There's no evidence that that ordering the plaintiffs outside and momentarily detaining them was in any way malicious under the Odom definition. And again, the elements of intentional infliction of emotional distress aren't met either. The defendants are entitled to summary disposition. We'd ask for a reversal.
Any questions? Thank you. Rebuttal?
Good afternoon. May it please the court, Racine Miller. I am here with brother counsel Michael Fortner, and we're here on behalf of the plaintiff appellee, the Wright family, consisting of Lisa, Joshua, and Philip Wright. First, I'd like to ask if there are any questions.
Depends on what you say.
Okay, fair enough. Your Honors, this is a pleading stage appeal. we can't really get into a fact argument, which is what sister counsel is trying to do. And she's trying to talk about whether or not there was good faith, whether or not there was malice. And from the factual record that has been developed, those are certainly disputed issues of fact material to the determination of this cause.
Do you dispute there was a shooting? I mean, is that a fact in dispute?
No, I don't dispute that there was a shooting of a police officer. What is disputed here?
Thank you.
Very welcome. Is there was a trail of blood left by the suspect. And we have record evidence that the officers who arrived on the scene, this blood didn't lead to the Wrights' home. It wasn't coming from the Wrights' driveway. It went through the backyard and he hopped the fence and they caught him. So trying not to argue about the facts of the case because it is whether or not we sufficiently pled, which we did. There was even testimonial evidence from the officers who arrived and, you know, why did you go to the Wright house? Oh no, just following these guys. That was what they said. They were not directed and commanded to go there. They had no probable cause that any crime had been committed. The Wrights themselves were not suspects. They were not in hot pursuit. There were no exigent circumstances here. She's trying to argue that they were. Now I'm trying to argue that they're not, trying to get away from arguing the facts. It's not what we're here for. What we have pled sufficiently in the complaint is not about the intent of the officers anyway. It's about their conduct and what they did. And even after they heard over the radio that the suspect had been apprehended, they remained at the Wrights' house. They left an elderly woman barefoot without a coat in the winter. Subsequently, she had a stroke, went to the hospital. They manhandled her grandson who was visiting her because she couldn't see at the time, so she was with him, and they broke his head. So you've got two people that unreasonable, excessive force was used on. They had no probable cause, no justification for even being present in the Wrights' home. Nobody told them to go there. There was no evidence that any suspect for any crime was there, let alone the suspect they were seeking. So to your question, Judge Rick, I don't dispute that there was a dead officer. Certainly that's a heated situation, but I do dispute that any involvement in the vicinity of the Wright home had nothing, there was nothing for these officers to do there. What they did was not authorized. They didn't seek authorization. In fact, they didn't even make reports that they were there. So that's part and parcel of what's telling. To further address Ms. White's argument, the exigent circumstances, whether or not they were, that's a fact question for the jury. And even if you want to talk about trying to accept their version generally, which as we all know is not the standard here on this, on a dispositive motion, they have identified no evidence identifying the scene of our civil rights egregiousness complaint. They have no evidence connecting that to any crime, let alone the suspect that they were in pursuit of. There was no fleeing suspect. They were not chasing anybody. What we allege is a conscious disregard. Good faith, that also requires a factual determination. And what we're looking at simply here is conduct so reckless as to demonstrate a substantial disregard for whether or not an injury will occur. That's what happened here. Did we plead it sufficiently? Yes, we did. The trial court so found. So what we're respectfully requesting today is that this honorable panel go ahead and affirm the trial court, let us go back down and move ahead. This is an incident that occurred in 2019. And here we are today at the pleading stage. Do we have any questions now? Thank you very much.
Any rebuttal?
Thank you again. Plaintiff's argument is largely based on whether either of the plaintiffs was a suspect. That's irrelevant for whether there was an exigency or not. We state that in our brief, but I think that needs to be underlined. But whether either plaintiff was a suspect isn't relevant to this at all, as to whether there was an exigency. There was an exigency. Police officer had been shot and killed. And and just to sum up, the elements of gross negligence have not been met. The elements of intentional infliction of emotional distress have not been met, even if it were to be recognized under Michigan law. And the defendants are also entitled to good faith immunity under Odom. So, so we'd ask that summary disposition, that the denial of summary disposition be reversed. Thank you. Any other questions?
No, no further questions. Thank you very much.
Thank you.
This matter will be submitted.
Thank you.
Turning to case number 9, or item number 9, docket number 371242, David Watson versus Lawrence O'Keefe. Sir, if you could state your appearance for the record and let me know how much time you'd like reserved for rebuttal.
Good afternoon, Your Honors. My name is David Powers. I'm representing the defendants, Lawrence and Jan O'Keefe. I would just like to save 2 minutes for rebuttal. Hopefully I won't use all my time. I'd first like to know that the O'Keefes are an elderly couple. Larry is about 80, Jan is about 70, and we're talking today about their home where they have lived for about 50 years. So I'd like to describe a little bit of the property just to get the discussion going. So we're talking about land up on Lake Huron in Sanilac County. The property is a 200-foot strip of property between M25 to the west and Lake Huron to the east. My clients own property on both sides. To the far west, they own what I'm going to call the M25 lot, and that's the north 100 feet. And then to the east, they own 200 feet of lake frontage. The north parcel is their home, the south parcel is their rental home. In between is where the defendants have cottages. Most of the cottages are to the north of the 16-foot road that goes through based on easements called Cottage Lane. One of the plaintiffs owns a cottage to the south. So that's the lay of the land. There's 2 issues before the court today that I want to talk about that is a subject of our briefs. The first is the trial court's finding of the water line that the trial court found is an easement all the way across Cottage Lane, but for our concern, he's also imposed it across our M25 property. The second issue before the court, as the court knows, is the definition of the term beach within the plan. I want to start out by talking about that water line issue, and I want to focus on that M25 lot. So if you are going to access this property at all, you are going to come to M25, and then you're going to turn east onto Cottage Lane. First property you're going to pass is my client's property.
Is M25 also referred to as Lakeshore Road, or is that a
I don't know
different?
the answer to that.
Your opposing counsel's nodding in the affirmative. Okay.
Okay, I'll take his word for that.
Okay.
And then the property to this, so there's Cottage Lane, which is a 16-foot easement. 8 feet of that is my client's M25 property. 8 feet of that is the property to the south of parties who are not parties to the lawsuit. So the trial court found that because of the existence of utilities on Cottage Lane or underneath Cottage Lane, that my clients acquiesced in or waived their right to contest the fact that there is an easement across their property. And I just think that that's outlandish. The record doesn't show that the trial court made no finding that there is anything happening with regard to the utilities on M25. There's no, I'm sorry, on my client's M25 property. There's no utilities under that M25 property. And so just based on the facts alone, let's talk about the utilities for a second. The gas comes from the property to the south and extends north to the defendant's, to the plaintiff's property.
Can I redirect you for a second, please? Remind me what you argued in your brief regarding, whether, let's say that water line's there. What did you say about what that matters? Like how does that apply? So the one, your client, let's say your client violated the easement, expanded the easement for the use of the water line. How does that turn into acquiescence? How are those two things connected? Why aren't they completely separate? Do you address that in your brief anywhere? Do you remember?
I don't recall that issue specifically. I know I talked about the existing water line. The existing water line is accessed from a well pump on the beach, basically, from my client's
Oh,
property.
I'm sorry, not the, it was a cable, right? Sorry, I was getting that mixed up.
Okay.
It was the cable.
Yes. So, let's talk about the cable for a second. So,
You do address that.
yes, I do address that. So it's a fiber optic cable, and that was placed, I think, in 2019, according to the records. And my client simply called the cable company and said, "I'd like cable."
Yeah. I'm asking you a hypothetical. Let's say your client put it there deliberately
Put it where?
in the middle of the easement.
Okay.
Like, and let's say that it was in violation of, an expanded use of the easement,
Yeah.
correct? Tell me how your brief, or how you say those two things are not connected.
So I just,
You understand am I being clear enough in my question?
well, let me try.
Well, I'll just say, because in my mind, those two things seem very different. They seem like separate kind of issues, and I'm not sure, I'm not sure how they are connected.
Well, I agree, because we're talking about whether we have acquiesced to something on our property, on our M25 property. And we can put a line on our property. I'm not saying that it is on our property. I don't think the facts establish that.
Yeah, I got that, but let's just set that aside. Yeah.
Okay. But I don't think, we can't have a waiver or acquiescence because we did something to our own property. And if the cable company put the line across somebody else's property, that's not an acquiescence on our part. We don't control that property. It's not a waiver on our part. We don't control that property. So I just don't understand how that could possibly be acquiescence on the part of my clients.
I guess maybe my question's actually for brother councils.
Okay, that sounds good. So what we have is we have these utilities. We have gas that's coming up from the south. We have water from the well that's coming up from the south. And then we have that fiber optic cable, which there's no evidence that any of those things are on our M25 property. So when the court made a holding that we acquiesced or waived with regard to utilities on our M25 property, there's no facts for that to establish that. I just don't know what the judge was thinking on that, quite frankly.
Well, I mean, I think the judge was thinking that maybe everybody here was, I mean, we've all been, three of us have been trial court judges, and you can see where maybe it's getting a little frustrating because a lot of this seems a lot more personal than practical. Do you understand what I mean?
I do. I don't know if there's facts to support that in this particular case, but I do
There's
understand
facts
that.
in there. There's all this so-and-so was spying on me, and there was a lot of back and forth actually, if you read all the transcripts that made this look very a lot of this was not very neighborly.
I don't think that should govern the law, of course, Your Honor.
It doesn't. It doesn't. I actually agree with you there.
Okay.
But I'm just saying, I think I understand that. To me is kind of where the judge was coming from.
All right.
Doesn't make it doesn't mean that it governs the law.
Right. Well, thank you, Your Honor. With regard to the facts aren't there to support an easement over the M25 property. And then I also argue in my brief that, waiver and acquiescence was not pled, number one. And number two, you can't, under Michigan law, there is no cause of action for easement by acquiescence or easement by waiver. And so if it would have been pled, it should have went out on summary disposition. But it certainly now at this point can't be the basis for imposing an easement over my client. And then finally, we have this whole issue of, okay, if you have one or two easements, does that mean it also includes a water easement, a water line easement? And there's no case law cited by the court or by opposing counsel for that proposition. And I haven't been able to find any. I have Westlaw. I've been doing a lot of research. I can't find anything that supports that. So I just think that the whole decision with regard to the easement over my client's M25 property just has no basis. So that takes me, unless somebody wants to ask more questions about that particular issue, I'm ready to move on to the issue of the plat. So we have a plat, and it's a plat from 1923, so it's more than 100 years old. And the plat, what's the purpose of a plat? The purpose of a plat is we want to get rid of property. We want to sell property. And so it plats 18 lots. We know that. It plats and dedicates a road. And it has a dedication of the beach. And when we look at the plat map, we see 18 lots. We see where Scott Drive is written into the plat. And we see this area, which is the beach. And it's the area between the plotted lot lines of the easternmost property and the easternmost line and the lake shore. And so that is shown on the plat. So it seems very clear to me that you have, unfortunately, what is the beach on the plat is not labeled, but everybody knows it's the beach. In fact, the trial court knows it's the beach because the trial court specifically ruled the beach is between Lake Huron and the Traverse Line for purposes of the plat. I don't know how the trial court moves beyond that, having made that finding that that's what that area is. That area is the beach according to the plat. I don't know how the trial court somehow moved on and said, well, but a beach has this definition from case law in the dictionary, and the beach is where certain sand is and where certain vegetation is. And so I'm going to hold that the beach moves from year to year or whenever, and we're going to identify the beach based on sand and vegetation, and we're not going to identify it based upon this plat. And I just think that makes no sense. First of all, we have this clear intent rule. We have a couple of rules of construction we're dealing with here, and one of them is the clear intent rule. The intent, if you're going to grant an easement in a plat, that intent has to be clear. Well, it's certainly not clear in this particular case. We have, and the plaintiffs don't even want to talk about this area that is unlabeled, but it's there. It's part of the plat. And I think when you construe the plat, you have to construe the entire plat. That's the second rule of construction I want to talk about today. You construe the plat as a whole. So you have to try to make some sense of what the platter was doing with this land that he hasn't labeled. And the only thing that makes sense, like according even to the expert surveyor, he said that the reference to the beach is this unlabeled land over here. And that only makes sense. But in my mind, you certainly can't say with all that, that the clear intent is that you're going to have a movable easement. So the second thing I'd like to talk about is just how the holding of the trial court of this moving beach easement is unworkable. And I have beach property. And so I've lived this. So on Lake Huron, the lake shore moves. And in this particular case, the lake shore has pretty consistently moved westward toward my client's home. Well, if you take what the trial judge did, at some point in time, theoretically, in my lived experience, this has happened. At some point in time, that water is going to get to that home. Now, what do we do? If you accept the fact of this moving easement, and under the law, the holder of an easement has superior rights to the underlying landowner for the use of their easement. So, hey, your house is in the way of me enjoying my easement. I want to put my beach chair down there and you need to move your house. And that is the argument that is going to be made under this kind of set of facts if what the trial court said is true. And that has more implications than just moving the house. It has the implications with the issue of seawall. Is my client going to be allowed to put a seawall in as the water continues to come toward his house because we have this moving beach that the trial court found? And I submit to you, no, my client owns to the platted lot line free of any easement for use of the beach. Now, that doesn't mean that maybe there is this beach walking right from the Glatz versus Geckel case of 2005. That's a separate issue. And I don't mean to even bring that in to confuse us, but there's that issue out there. But what I'm talking about is a real estate right because of the easement that I get to remove your house potentially, prevent you from building a seawall because you are impairing my right to walk the beach. So I think we have that practical problem. Now let's take another example. Oh, I'm preparing. I wanted to tell you that I have that lived experience. My parents had a cottage on Saginaw Bay. The water, it was on stilts. The water washed underneath our cottage. Under this scenario, somebody could argue that cottage has to go. And I just don't think that's right. Okay, now, what if something else happens? Like under the Hilt versus Weber case from 1930, they talked about the concept of reliction and the water goes down. What if the water goes down and we have a new 1,000 feet of beach? And so now the beach is way out there and this platted land that we have that's unlabeled is 1,000 feet away from the beach. And so now what do we have? Who owns that platted land? Is it no man's land? Because this court has said that's not the beach, apparently, because the beach moves. So if that's not the beach, then who owns it? And arguably, if property hasn't been dedicated or sold, then it's going to go back to the platters. I had a case like this once up in the Tawas area where we made this very argument and were successful. So the property goes back to the platters. Well, those platters were there doing it in 1923. How many heirs are we going to have to chase down? 300 heirs to find the platters to do something with this real estate because they all have ownership's interest in this real estate? No. The intention of the platters in 1923 was to give up ownership or to provide for an arrangement where they were going to give up ownership of everything within the plat. That included that land between the lake shore and the eastern point of our lots. So in my view, the trial court's decision on the plat issue and where the beach is doesn't make sense. It doesn't follow the rules of construction, and it's just unworkable. And unfair to my clients. That's all I have.
Your counsel?
Thank you.
Thank you.
May it please the court, Alan Francis for plaintiffs and appellees. I know there was a question that's probably coming to me, but I actually am gonna go in reverse order and talk about the beach issue here first. So we have a lot of proposed hypotheticals about what could or couldn't be an absurd result. What we have in this case is a real life absurd result that was proposed by the defendants. So the defendants sent a letter in 2019 to my clients, despite the fact there'd never been an issue with using the beach in the 35, 40 years that the oldest of my clients had owned property. Send a letter that says, hey, we got a survey. This is where our property line is. You can use the beach if it exists east of the property line, but you can't use the beach if it exists west of the property line. So the testimony was, yeah, there's a beach in the plat, but you can't use it because it's east of the line. And so that to me is the absurd result. And frankly, by the time we got through trial, they had moved to where it was not, it was not west of the line anymore. But we have my clients who bought these cottages, who bought pursuant to the plat. The plat grants them the right to use the beach. Stop. The plat could have said and used similar language that it used for the streets, literally 4 or 5 words before, where it said the streets as shown or depicted. It doesn't say the beach as shown or depicted. It says the beach. It doesn't label the beach. So to suggest that the trial court erred by applying not only a dictionary definition, applying a definition this court used admittedly in a non-published case, but more importantly, applying the definition that all the parties and the surveyor said when asked at trial, what is a beach? And they all said the sand and pebble areas between the water and the shore. So, we have parties, we have surveyors, we have everybody, and we're stuck on the trial court erred by using a common sense dictionary definition of beach for something that's not otherwise described in the plat. I don't think there's any basis to find that the trial court clearly erred, conducted a full trial on this matter, took the evidence, took the testimony. It's not defined elsewhere, so the judge has to define it somehow, and he used an appropriate definition that frankly isn't disagreeable with anybody. So I think this idea of what could or couldn't be a hypothetical in the future, I don't know what's going to happen. I know that there was 50 years with no issues, but I do know that we had a proposed absurd result that frankly is what started this litigation. So I'd ask this court to affirm the trial court's decision regarding the beach. Now, to get to Cottage Lane, I'm a little bit confused, or I don't want to be confused by the argument. So Cottage Lane runs from M25 Lakeshore all the way back to Brother Counsel's client's lakefront property. So it's not a situation where the Cottage Lane easement is somehow broken up by other properties that run along M25.
That part of Cottage Lane, where the cable line is dropped allegedly.
Correct.
Just clarify for me, I just want to make sure I understand. That is actually owned though, by his client, correct?
So the testimony at trial was my client, Mr. Watson, was present when the fiber was being laid.
No, the lane itself, the
Oh.
road that's right
Yeah.
there, that's at issue.
Correct.
They own it, right? So we're talking about like the use of the
Well,
easement.
subject to the easement, they own it. Yeah.
Subject to the easement,
Yeah,
right?
I think
Okay,
they
got
would
it.
own part of it, yes. And so to answer your question, well, it was 2 8-foot easements is why I said part of it. They're combined to make a 16-foot Cottage Lane. They only own, my understanding, the M25 parcel that they own is only on I guess it would be the north side of that easement.
Okay, so they own half the road? Is that what you're
Yeah.
clarifying
Yeah,
for me?
yeah.
Okay, and then your client owns the other half of the road?
As it goes down, actually, it's owned by people on the other side. My client, I know, my clients are all except for one on the north side of Cottage Lane.
Okay, so your client doesn't own the other half of that road then?
Correct. They're all,
The fiber optic, the cable that's like smack there in the middle of that road. Now I
Well, this is, if I can, and I'll gladly let you interrupt me, but I'll try and explain it. 'Cause
Okay, I'll take
to
that.
the best I can. Mr. Watson, my client, was out when the fiber was being laid, and I think as you suggested, he indicated it was laid right down the middle of Cottage Lane. I do not know, and it's not clear in testimony whether it comes from the middle of Cottage Lane all the way to M25, or if it starts out on another parcel and then kind of goes into Cottage Lane and M25. That would depend on where the pole is on M25. All my client knows is that by the time it gets to his parcels along Cottage Lane, that fiber runs down the middle.
What does his client have? I'm trying to understand what that has to do with changing the use.
Well,
Of an easement.
it expanded the use of the easement to be more than ingress egress into utilities.
But if he owns the road, if
Well,
your client doesn't own the road at all,
But he doesn't own the whole road. And
but
I'm
that's not your client's road though. I
correct.
mean,
We're using the road to get to the back half as easement holders, even
But
Mr.
but if he's an underlying owner, then I'm trying to understand. I'm missing something. There's a
Yeah.
piece missing and I just couldn't get there and I'm trying to
So
understand it.
my understanding is there's an underlying owner of the north 8 feet, but I don't believe that's where the fiber was laid. It was laid in the middle, which would be that's what the testimony was. It's laid in the middle of Cottage Lane, which would be, on either side of the easement. He doesn't own the south half of Cottage Lane. That's owned by the Tibbets, I believe is the name. They're not parties. I understand they're not parties, but they're not parties to this lawsuit. But there's also the natural gas line. So they're related in that our position is that the defendants have taken inconsistent positions with respect to what this easement is. At one point in time, it's for fiber. There's natural gas there that's not disputed. And more importantly, in 2020, when defendants send out these emails saying, we know we're supposed to be providing water to you from this beach well, it's contaminated, it's damaged. We're gonna, we agree that M25, there's water access, we can run it down Cottage Lane, we got pricing for it. At trial, the only reason we're not consenting anymore, and this was suggested to earlier, is because we don't want Barry and Denise are DeBar Holdings, one of the plaintiffs. We don't want Barry and Denise to have water.
So as the underlying owner of property, I can do whatever I can do mostly what I want with the property if I'm not interfering with your easement that's there, but
Right.
I still have priority over the property. And if that cable line isn't doing anything to somebody driving back and forth or, that's what it's for, the easement on the property, I'm having trouble understanding how it fits into this argument.
If it's on their property, I don't think the record is clear. All we know is that it was down the middle.
Okay, but that the other party whose property is here, I mean, I actually I'm not even sure that matters because you're talking about your client's ability to go in and out of the property.
Right. It does not, it's correct. My position is that they are at one point saying it's ingress, egress only, and then at another point saying it's fiber, and then another point acknowledging there's natural gas. And I don't think you get it both ways. I'm not disputing whether there might have been rights outside of that, but they also said the fiber can be used by anybody. And then they said they were going to pull the fiber. This is it is a very personal lawsuit. For some reason, there is animus with respect to at least one of the parties. And that the installation of a water line, it doesn't exist. There's no water line that's been installed as we're sitting here today. There's water at M25. And I think importantly, the judge determined that it would violate public policy to not provide usable water to my clients. That hasn't been appealed. And it's also not in dispute that the water that is being provided by the defendants via this contaminated beach well is not usable for any real means. So that issue
was this filed as a contract dispute though? That was part of the contract, right?
Well, it was filed as, there was a water use agreement that the judge ruled, there was old water use agreements that the judge ruled were replaced by subsequent water use agreements. And the judge ruled that we would have the ability to use, which is consistent with what the old water agreement said. The old water agreement said, we will provide water until you have access to municipal water. Judge Rathel said those are gone, but replace them with the subsequent water agreements, which Mr. O'Keefe said were designed to have the same term. Designed to have the same term of use. So the term of use would be until we can connect to municipal water, which we have the ability to do. There's no dispute about that. There's no dispute that the water that's being provided is not usable. And there's no appeal that Judge Rathel's decision regarding it would violate public policy not to allow us to access that water. There's no dispute that that was an incorrect decision. That's not on appeal. So that's the issue with respect to the water. I don't have much more. I don't want to consider it a waiver. I don't need to talk about it, but we briefed the issue about timeliness on appeal. If there's any questions, I'd be happy to answer those.
No questions.
Thank you, Your Honor.
Thank you very much. You have the 2 minutes for rebuttal, Counselor.
Thank you, Your Honor. Maybe I'll start from the freshest. The court did say that it's against public policy to deny someone potable water, and there's no law for that. He didn't cite any law. Council doesn't state any law. And we absolutely contested that in our briefs. And if there's any question, I contest it today.
Well, I mean, it's in the contract, right? It's that they're supposed to be getting potable water.
There is a provision in the contract that says that if they get water, then the contract is done with.
Right, but they're supposed to be getting, but they didn't, I mean, that's not what the lawsuit is, though.
We're not suing over that. Yeah. Just so the court knows, there is no water line installed. My client told me the other day, everybody has wells now, so it's unlikely that there's going to be a water line installed. I don't know that that matters to anybody, but I just thought we'd mention it. I think it's telling for council about the question about the fiber optic cable. It's not clear that that went over the M25 property. In fact, I think it is clear that it didn't go over the M25 property. There is no court finding that it did. And so that can't be used as part of the acquiescence argument. Council says, and we're going to talk about the beach. Council says that our argument, we talk about absurd results, and they counter with that they have an absurd result. And I would say, no, they still can use the public trust doctrine to use the beach wherever they find it. I'm not going to sit here and tell you what the extent of that right is, but to the extent that anybody else in the public has the right to use the beach, his clients have the right to use the beach, at least as it's part of the shore, because there is the issue of easement. They have a limited easement right to get to the beach to use it. Because they only have a right to get to you. They only have an easement to get to the shore.
Counselor, you're at your time if you want to just wrap up your argument.
Thank you, Your Honor. That's actually, one last thing. What happens with that undefined land? Council didn't tell us. That's all I have.
Thank you. This matter has been submitted. Turning to item number 10, docket number 378026, Solange Spinelli de Carvalho Santos versus Bruno Vinicius de Santos. Did I say that correctly?
Pretty close.
All right. All right, Counselor, how much time would you like to reserve for rebuttal?
Your Honors, I will reserve 3 minutes for rebuttal, please. Good afternoon. At this point, Jeffrey Wagner appearing on behalf of the appellant mother, Solange Spinelli, who is present in the courtroom today. I'd also like to state that we have 2 of our summer associates who just joined us for the summer who are here to observe today. And it's been a treat for them to watch such interesting arguments before the panel.
Welcome.
This case, Your Honors, involves an appeal from the Oakland County Circuit Court, which granted sole legal custody and primary physical custody of the party's 9-year-old daughter, who we refer to as MCS in the pleadings, to the appellee father. We come here today raising 3 specific issues, which in our view amount to reversible error. The first and second dovetail because they relate to the trial court's findings on the established custodial environment issue. So I'm going to address those in tandem, and then after I speak to those issues, I'll address our issues with the court's best interest analysis, which, as we note in the pleadings, was reversible on the ground that it was, one, punitive in nature insofar as it prioritized the contempt findings over the best interest of the child, and two, ignored significant evidence from the minor child's treating therapist, Miss Medina, whom she saw over 114 times, and in fact testified under oath that she did view this child as being sexually abused. But I want to start on the procedural issue because oftentimes in these custody cases, the trial court's finding on the established custodial environment issue is going to be outcome determinative for the simple reason that it dictates the standard of review. If there is an ECE with a parent, then the motion from the other parent is going to be adjudicated under a clear and convincing evidence standard, as your honors know, which this court has said time and time again is the most exacting civil standard of review that this court or any other applies on a day-to-day basis. If there's not an ECE, on the other hand, we're looking at a mere preponderance standard. And the first and foremost, the most significant error that I've read the voluminous record multiple times. I've read Ms. Argaroff's excellent brief multiple times, and I've not seen any evidence, nor have I seen any published case law or unpublished case law that has looked at a similar limited period of time when we have a temporary custody order. In this case, from the time that the temporary custody order was entered in January of 2025 to the time that the parties were litigating the evidentiary hearing before the referee and then the de novo hearing between Judge Gorsuch in the summer, we got a period of roughly 6 months, which represents, by my math, about 1/16 of the minor child's lifespan. We have an 8-year-old who, up until the time of that temporary custody order being entered, was primarily cared for by the plaintiff, her mother. We look at the testimony that was provided at the evidentiary hearing, and Dad concedes that point. He says, yeah, my daughter has a clear, a very deep relationship with Mom, and Mom has been providing guidance with respect to school, therapist visits, and just responsibilities that we do as we care for our kids on a daily basis. And similarly, Mom's testimony at that point was similar. She was the one responsible for school appointments. She was the one responsible for extracurricular activities. She was the one, again, who, when behavioral issues arose at school, was taking MCS to Miss Medina for those 100+ therapy visits. And if we turn to the decision from the referee and ultimately the opinion from Judge Gorsuch, we see really scant analysis. And I would say, I've looked at the 24-page opinion, or I could be I might be wrong on the number of pages, but the amount of authority that is dedicated to justifying the conclusion that MCS did not have an established custodial environment with her mom at the time of the custody hearing, there's really no attempt to meaningfully grapple with that question. And not only is the decision against the great weight of the evidence insofar it was not consistent with Dad's testimony or Mom's testimony, it's also belied by the published decisions from this court that have looked at similar situations where you have a temporary custody order that's in place for a few months. And the question becomes, at what point does that months-long period amount to a, quote, appreciable time for purposes of establishing an established custodial environment? And as someone who appears before this court on both family law matters and other business disputes and other civil matters, I'm often frustrated gearing up for family law cases because the cases can be so fact specific that it can be difficult to find the 2 or 3 leading cases that I really want to emphasize in my remarks before the panel. But this is not one of those situations. We cite to the Becker case from 1980, decision of the Court of Appeals. Similar situation where they looked at a roughly 6-month period and found that because the child had been reliant on Mom for all but that temporary period, the trial court erred in finding that Mom had in effect lost her ECE status by virtue of that temporary order being in place. We also cite to the Pluta case, 1987 decision from the Supreme Court, or from the Court of Appeals. And similar situation, but from the other angle there, where they said about 5 to 6 month period, and we don't think that dad, who had been the more part-time caretaker in that case, we don't think, this court concluded that that 5 to 6 month period was not sufficiently long to, in effect, create a new ECE with him and effectively erase the strong bonds that had developed between the child was 7 in that case. So the calculus was you had 5 to 6 months on one hand, 7 years on the other, and was that relative blip on the radar of the young child's life, was that enough to unwind the deep bonds and reliance that had transpired over the course of the years? And the court said, no, it wasn't. And the issue with those cases is when you have findings that result in a preponderance of the evidence standard being applied when a clear and convincing evidence ought to be applied, you're really stuck in a situation where, though, I think the trial court attempted to insulate itself from appellate review on that process by dropping a footnote in the opinion, which said something to the effect of, well, even if there was an error on the standard of review, I find that it still meets the clear and convincing evidence standard. I don't think that is persuasive, nor is it sufficient to overcome the evidentiary issues that I addressed earlier in terms of the testimony from mom and dad, nor does it distinguish in a meaningful way the effect from a precedential standpoint of the Pluto decision and the Becker decision. Now, the procedural issues I think are significant, but I think perhaps what I kind of look at as the more substantive deficiency with the challenge relates to the best interest analysis. If we take a look at the transcript from what transpired below, I think it's fair to say that the judge became frustrated with the way that mom behaved during the trial court proceedings. And as I noted in the brief, I think on many levels that frustration was totally understandable and justified even. I have tremendous respect for Judge Gorsuch. I've appeared in front of her. Her husband, David Gorsuch, has been one of my law partners for more than 10 years. But I think we have a situation where, again, the sheer frustration with my client resulted in the best interest of the child being relegated to something of a footnote or a minor concern, as opposed to the North Star that the Custody Act says it ought to be. And again, turning to my remark before about sometimes struggling to find precedents to focus arguments on in these family law cases, we cite to the Mitchell case, unpublished decision from 2011 from this court, which is strikingly similar in terms of its facts and law. In that case, we have a situation where mom's live-in boyfriend was refusing to provide identifying biographical information. The court said, no, you're going to give me this gentleman's name and this info because he is around the minor child, and I am finding that it needs to be disclosed. And if it's not, I'm reserving my ability to impose contempt sanctions. The boyfriend and mom remained defiant, refused to do that. And similar to this case, we have a situation where the contempt penalty is issued, but the judge then goes a step further and also becomes frustrated to the point where there's going to be a custodial ruling made that primarily focuses just on the refusal to accept the authority from this court. And I don't mean to minimize the significance. Judges issue orders and they need to be followed. It's integral to the rule of law. But at the same time, it is, I think, important that in our family law jurisprudence, we recognize that the court's contempt powers are certainly important, but they don't necessarily focus on the same priorities or goals as the Custody Act. The Child Custody Act is focused on the best interest of the child. And in the trial court's findings relative to the best interest factors, it is striking to me that the focus of the trial court on virtually every factor is dominated by focus on the contempt violations that occurred.
Excuse me, counsel, sorry to back up a little bit, but you weren't arguing that the trial court put on the record a different standard than clear and convincing. You're just saying that the soliloquy that happened after doesn't meet that clear and convincing. Is that correct? Am I understanding your argument?
I am arguing that both the referee and the trial judge applied a preponderance of the evidence standard to dad's request to change legal custody, to have him be the sole legal and primary physical custodian, when the standard that should have been clear, it should have been clear and convincing, because in our view, mom, who had been the de facto parent and primary guardian for the vast majority of the child's 8 years on this planet, that there was no, the finding that she had effectively lost that ECE status was against the great weight of the evidence, which in turn resulted in the case being adjudicated under a preponderance standard as opposed to clear and convincing.
And the court labeled it as such as?
In its opinion, certainly.
Okay, all right.
The court made two findings that are, in my view, equally flawed relative to the ECE question. One, that MCS at the time of the custody hearing did not have an established custodial relationship with her mother. I don't think that's supported by the evidence, nor is it consistent with the case law. The court also found that MCS did have an established custodial environment with her dad, who had been more of a part-time parent for the vast majority of her life. And I think those should have been inverted, frankly. I think that looking at the totality of the circumstances, which although in sister counsel's brief on appeal, there's a focus to the Sabatine case, opinion authored by former Justice Viviano, which talks about what is the time period for which a trial court is looking to whether an established custodial environment exists. And the court, Justice Viviano says in the unanimous opinion, we're looking at the situation that exists at the time of the hearing, but we're not looking at it in a vacuum. The opinion goes on to say that in cases, it will often be necessary to look at what's transpired in the past, because I mean, it would seem like an obvious time in my reply brief to Shakespeare, but past its prologue is just the reality. You can't look at what a child is going to do in terms of to whom he or she is looking for guidance, care, and basically advice in terms of how to live life at a specific moment in time without taking more of an expansive view to what has transpired in the time leading up to the hearing. So again, we have part of this record, we have, I think, two glaring procedural layers relative to the established custodial environment that resulted in this case being adjudicated on a wholly inapplicable legal standard. I think related to that, we have a best interest analysis that was not carried out in a manner that was consistent with the chief objectives of the Custody Act, and which took the concerns in terms of the contempt of court that occurred and basically placed myopic focus on that, which had the effect of using a contempt finding as the primary vehicle to change legal custody, which this court and our Supreme Court has said is an improper and unjustifiable decision because it simply doesn't prioritize the best interest of the minor child. Unless the court has any further questions for me, I'll reserve the rest of my time for rebuttal.
No further questions. Thank you very much.
Good morning or good afternoon. Ann Argeroff for Appley Bruno Santos. Briefly, I believe our brief addressed all of these issues, but to focus on the established custodial environment, counsel states that it's based on when the hearing was held. I believe Sabatine, which was my case, mentions that it's as of the time of the court's decision. And so our brief discusses in detail that the parties shared joint custody prior to their divorce in 2022. They were awarded joint legal custody, physical custody in the judgment of divorce. Beginning in the spring of 2024, Ms. Santos started filing a number of unsupported multiple petitions and motions in multiple jurisdictions. They were all determined to be unsupported and were either dismissed or denied or rejected by the courts or by CPS. She was planning to move to Ohio. She moved briefly to Ohio. She was in Ohio and she made filings. It's all detailed in the brief on appeal. She made filings. There was testimony at the December 6th, 2024 hearing, which was originally, that transcript was not provided by appellant, where Officer Todd Stanfield, I believe, testified that she had been untruthful about, and I'd have to look back at the exact language, untruthful about allegations that had been made on certain, in terms of certain things that she'd requested regarding possibly a PPO. But again, the details and the correct data is contained in our counter statement of facts. So we had a disrupted period of time from roughly spring of 2024, where this child was taken to Ohio, brought back, not seeing a parent. Mr. Santos received makeup parenting time. So you had a disrupted period. Then based on everything that had happened, not just talking about contempt, but talking about the behavior and the choices and the unsupported requests that had been in motions and petitions that had been filed by appellant. The court looked at all of that. The court looked at that I believe discussed that disrupted period, focused on the party's behavior. We were also dealing with, unfortunately, an immigration issue and behavior that may have affected the child's status in the United States. That's discussed in our brief. So we're looking at behavior that did not provide stability for a child, provided a chaotic situation, and all that resulted in the January 9th, 2025 order that granted father sole legal custody and primary physical custody. From that time to now, the child has lived a more stable life. We can look at Sabatine again, and I believe, but Sabatine says you look at the ECE as of the date of the court decision. But I will double check that. But I believe, and there's no mathematical formula in family law. You have to base it on the specifics, the unique circumstances of every case. This case, we had a parent who was acting erratically. And again, we're not just talking about contempt findings. We're talking about not being truthful. We're talking about saying things that have never been supported and subjecting a child to, at a minimum, uncertainty. And this is a child who doesn't handle disruption well to begin with, as discussed by one of her counselors. And very briefly, fellow counsel states that he relied on the Mitchell case. The Mitchell case is not on point at all. Mitchell was remanded. There was Mitchell 1 that was unpublished. It was remanded to the trial court because it was a Beretta type situation. There had been no findings under the requisites of the Child Custody Act. And we see that, unfortunately, fairly commonly, that courts make decisions without evidentiary basis. It was remanded for that. It wasn't remanded for the reasons or sent back that counsel stated. And Mitchell 2 granted custody to the father who had requested, and that was published. So you can review both Mitchell cases and see that I don't think it's particularly enlightening in terms of their points. I do think that the trial court's decision was firmly based on the great weight of the evidence. We're dealing with a very tough review standard in terms of child custody cases. We're dealing with, against the great weight of the evidence, clear material error, and palpable abuse of discretion. The trial court made detailed findings under each of the factors and found actually for father on 6 factors, favored appellant under 0 factors, found 5 factors neutral, and interviewed the minor child. And that was not, of course, the preference of the child was not released. So we're looking at what the courts, and under those, I mean, again, we're dealing with layers of subjectivity and deference to discretion. But this court addressed the facts that were before it and found the great weight of the evidence, or it's just made a decision based on the great weight of what was before it. And we're not looking at, oh, it was 6 months, oh, it was 7 months, oh, it was 3 months. Reliance on those other cases, we're not looking at time period. We're looking at sufficient enough time where a child can be in a stable environment. And the child was in a stable environment for at least 10 months with the father, pursuant to an order. Not that an order is required. Under Blaskowski, we look at the reality for the child. We don't look at whether there's an order or not. And I believe that Sabatine discussed Blaskowski. So we're looking at a decision made by a court that saw what was going on in this case for a period of a significant period of time. There were extensive evidentiary hearings. The referee saw the same thing. The decision was based on the great weight of evidence. There is not a palpable abuse of discretion. And in terms of saying the court did find that dad had and the child had the established custodial environment. It didn't say the child had no relationship with mom, but the court found that the environment based on stability, based on reliance, based on sort of a stable day-to-day life was with dad. Certainly by court order as of January 9th, 2025, and in light of the disruptive period before that. In that situation, under Stringer, under Merrick, preponderance of the evidence is the evidentiary standard. But the court also said clear and convincing evidence would apply too. And the fact that no factors favored mom, 6 factors favored father, including B, C, and J, which are major factors, and 5 were neutral, could also constitute clear and convincing. We are dealing with ample and discretion, which gets great deference from this court, and they have failed to show anything, I think, satisfying Section 28. The last point too, a court can consider one factor under one consideration under numerous best interest factors. And the court may have mentioned contempt, but the court also discussed, again, all the different behaviors in this case, the untruthfulness, the manipulation of what was filed, what was said to different officers in terms of trying to get some kind of ground under her feet to get for her custody claims. So the focus was the child. I think, again, there was it wasn't nothing against the great weight of the evidence. It was clear error, there was no clear material error, no palpable abuse of discretion. The court did a detailed analysis, and their brief does not set out details under, doesn't do a deep dive under the specific best interest factors. We tried to specify what the court did address, and I believe on page 34, 35, 36, I discussed what was under factor B. But again, we had no specific, they just said the whole thing was punitive. It wasn't punitive. It was protective of the child.
So am I right? I was trying to remember from the last time I read this, but the referee did use the preponderance of the evidence standard, but then went on to apply the clear and convincing, said if this was, however, even if the court was required to apply the clear and convincing standard, did the referee do that, or do you remember?
I remember, I believe the judge did. We can look back and I can say something. We see that all the time, though. We see courts say, I would apply this standard, but I think it satisfies the more stringent standard too. And here you had factor after factor that went to dad, and based on a number of considerations, and I feel that they didn't clearly set that out in their briefs. I discussed that. But I think the court made findings under all of the factors, discussing everything in actual fair detail. There was a 23-page opinion, and I think the referee did too. So I think we have detail there, and I think they did not support their burden. And this child has been living a stable life. All right, any other questions?
No, thank you very much. You have 3 minutes for rebuttal.
Thank you, Your Honors. I want to finish my remarks today where I started off in my brief on appeal, which is reminding the panel what this case is not about. And this case is not a case about manufactured allegations of abuse. In both the CPS testimony and the testimony from therapist Medina, it is undisputed that the complaining individual who raised the possibility of abuse with the authorities was not my client. Rather, it was a neutral, qualified therapist who blew the whistle and said, we need to look into something. And that fact is not apparent at all from the trial court's opinion, which repeatedly uses kind of caustic and vituperative language towards my client, accusing her of making untrue and unsubstantiated allegations. And that was the distinguishing factor in the Mitchell 2 case that sister counsel argued. On remand, it's true that the decision to change custody was upheld, but two things, and I touched on this in the reply. One, it's the remand for the case to be adjudicated under the proper legal authorities that we're primarily asking for. And two, in the published Mitchell decision, Mitchell 2, the primary rationale for the decision to change custody being upheld was a conclusion that mom had manufactured the allegations in that case. One, mom is not the source of the allegations in this case. Two, she therefore can't manufacture them because she didn't make them. And three, we have testimony which has not been contradicted by any of the witnesses who testified at trial that it was in fact Miss Medina, the therapist who had seen the minor child 114 times, who raised the issue of abuse. I think that is a distinguishing factor between this and Mitchell 2. And I think that on balance, although I don't disagree with the deferential nature of the standard of review, I made a very similar argument a few months ago to the one Ms. Argerop just made. But again, we have clear legal error on a major issue, which is the relevant language from the standard of review here. And we have that here both in terms of the established custodial environment and the standard of review that was applied. And we have that in the best interest analysis insofar as it was punitive, myopically focused on the contempt finding, and fundamentally misconstrued the testimony from the therapist, which provided a neutral and legitimate basis for the concerns that were ultimately examined by the authorities.
Well, I'm looking at the court's written opinion and factor L. That doesn't pertain to the CPS reports, but the allegations made in the UCCJEA petition, the information pertaining to the PPO in Ohio, failing to provide father with parenting time pursuant to valid court orders. I mean, those are, that doesn't jive in my mind with the representation that this was all based on the CPS reports and attributing those reports to mom when they came elsewhere. I mean, do you acknowledge that there were these other issues?
I acknowledge that the judge made credibility determinations that were not favorable to my client, and those are reflected in the opinion. And I don't necessarily quarrel with those. I think the issue, though, is if you look at the portion of the opinion that's excerpted on page 11 of my brief, the judge refers to, quote, the harm that those baseless allegations, which again refer to the statements made to CPS and law enforcement, have done to the child. So to criticize my client for making what the court refers to as quote unquote baseless allegations, when one, she's not the source of them, and two, they are made by a therapist who's seen the child more than 100+ times, I think is problematic from an evidentiary standpoint.
That's but one piece, I guess, is what I'm gleaning from the court's order. Even if we set that aside, we've got the UCCJEA petition, the loss of employment due to incarceration, vague or non-responsive testimony during the referee hearing, repeated denials of parenting time, and pursuing a PPO in Ohio, and then after it was to effectively suspend dad's parenting time, then withdrawing it. I mean, those are independent of the CPS reports.
There are certainly factors that were addressed in the best interest analysis, but I don't think it unwinds the errors that occurred from a procedural standpoint with the ECE and the wrong standard of review being applied. And I think that although those factors are referenced, I still think that the overwhelming focus of pretty much every best interest factor is the contempt finding and also the judge's suggestion that my client was the independent source of the allegations. And I just don't think those pass muster under really any standard of review. Thank you, Your Honors.
Thank you very much. All right, thank you very much. This matter has been submitted. Turning to item number 11, docket number 371-777, People of the State of Michigan versus William Michael Badger Jr. Appearances, please.
Good afternoon, and may it please the court, Jonathan Simon on behalf of Mr. Badger.
Good afternoon, Mr. Simon. How much time would you like reserved for rebuttal?
Not much, if any. I don't think that there was any question that Mr. Badger was intoxicated. His blood alcohol level was 0.18. I don't think that there was any dispute that he operated a motor vehicle. He acknowledged that. Also that a death resulted. The focus of my argument is that there was no evidence of reckless operation of a motor vehicle resulting in death. This was a 55-mile-per-hour road. Mr. Badger estimated his speed at about 65. One of the prosecutor's witnesses guesstimated at maybe about 70, but the expert who actually ran the black box found that it was 63, even less than Mr. Badger had guessed, and less than 10 miles over the speed limit. The vehicle went out of control, and it flipped and landed upside down in a culvert that was filled with water. The decedent died not from injuries which were sustained as a result of the collision, but from drowning in the water-filled culvert in the upside-down vehicle. The elements of reckless operation of a motor vehicle include willful, wanton behavior. We just don't believe that under the circumstances, the facts of this case, that was proven. Certainly there.
We have testimony that he ran a stop sign, he was speeding, and he was drunk?
Well, he was drunk, yes, and that was covered under count 1, OWI, and resulting in death.
That's also evidence of recklessness.
Well, it's evidence that of intoxication, which was count 1. Recklessness, I don't think so, because they have to prove willful and wanton behavior. Yes, there was testimony that he ran a stop sign. There was testimony that he was slightly less than 10 miles an hour over the speed limit. The expert who clocked it based upon the black box concluded that he was operating too fast for the conditions, which is a civil infraction, or that there was a speeding, which was also a civil infraction. Reckless operation of a motor vehicle is a misdemeanor. That's a crime, and we just don't have, I think, under the facts of this case, evidence that there was that crime of reckless driving, which resulted in the death. Now, this is not an exercise in just for the purpose of making, an argument. It is significant because it changes the guidelines. Now, Mr. Badger received a 58-month minimum on each of the 2 counts. However, if you vacate the conviction for reckless operation, that makes a change in prior record variable 7. It would reduce it by 10 points. It would reduce his total OV his total PRV, and resulting sentence guideline range from 36 to 71 months, which was within the 58-month range, down to 19 to 48 months, which would make the 58-month minimum sentence a departure. And so we believe that not only should the conviction of reckless operation of a motor vehicle be vacated, but that as a result, Mr. Badger should be resentenced for the operation of a motor vehicle intoxicated death resulting. And I know that there's two other arguments, but this is the one I think which deserves the most attention to this court, and we respectfully submit that that relief should be appropriate. Thank you.
Thank you very much, Council.
Afternoon, Jennifer Bruggeman on behalf of the people, Lenawee County Prosecutor's Office. I'll address the sufficiency argument, just to point out, in addition to the drinking and the speeding, which varied between 63 and 80, depending on the witnesses and defendant's own admissions. He admitted going 65. There were multiple eyewitnesses to this, not necessarily from the beginning of when defendant and the victim took the car to basically intentionally see how fast it could go. There's witnesses that first heard high RPMs, awful noise, equated it to a low flying plane, and literally saw the vehicle take flight. And when they blew through the stop sign, hit the dirt road on the other side of this, it was pavement, blew the stop sign, hit the dirt road on the other side, and unfortunately flipped over and landed upside down. It was a convertible. Mr. Badger knew full well what he was doing that day. They intentionally left the home of the victim to go get more alcohol. While obviously there was nobody else in the vehicle other than the two of them, so we don't know exactly what happened from the time that they left the liquor store to the accident. Certainly the intention was to, where they were located was not even near the liquor store or near the victim's home. And so the inference can be made that they intentionally went this direction to see how far this newer vehicle would go. You know, and then just in terms of the defendant's state of mind, I think based on what he did after the accident, in terms of not wanting the victim's wife to give the police the black box, intentionally telling the wife that the car slipped into the ditch, and basically lied about the details, blaming the victim that he probably died from an aneurysm, telling the victim's wife that his blood alcohol results were as a result of his diabetes, or they weren't correct. Things of all of that nature. I think when you take the entirety of the testimony as well as just the overall evidence, it is clear that there was sufficient evidence on the reckless. I'm happy to answer any other questions on the ineffective claims. There's kind of tied in there was the prosecutor misconduct kind of allegations, as well as the proportionality of the sentence. Those were the other two arguments. I'm happy to answer any questions. Okay, thank you.
Rebuttal?
Briefly, where the vehicle was at the time of the crash and how it got to be at that location as opposed to closer to the liquor store or closer to the home is mere speculation and not evidence of recklessness. And anything that was said, any distancing from what had happened afterwards is again also not relevant, in my opinion, to what happened with to the whether or not there was reckless behavior. Attempting to make false exculpatory statements is interesting, maybe in terms of something like a offense variable 19 situation. But as far as the crime of reckless driving causing death, I don't think it is relevant as to what occurred subsequent to the collision, to the accident. Thank you.
Thank you very much, Counselor. This matter has been submitted. Moving on to item number 12, 377-529, People of the State of Michigan versus Andrew James Christensen. And we only have appellant endorsed for oral argument here today, so you have 15 minutes.
Good afternoon, Your Honors. Jennifer Gonzalez on behalf of Mr. Christensen, the defendant in this case. So I want to start with the corpus delicti issue. The people said that the statements made did not constitute confessions, but the crimes themselves. And the magistrate at the preliminary exam said that upon my objection, that the calls are part of the allegations as to whether or not a threat was made. That's because they did not introduce the elements prior to introducing the call, which is the necessary requirements for the corpus delicti. These were self-incriminating statements made by my client in these phone calls with police officers. And specifically in the second call, he admits to making that first call and seeking out Officer Karpuk's pastor, which, taken in conjunction with his Facebook posts, was to speak to the pastor himself and gain some insight, and essentially at a place of worship. Additionally, just as in People v. McMahon, where the defendant could not be prosecuted for murder due to the corpus delicti violation, the court there said there are any number of reasons and explanations for an individual's disappearance. That's akin to this case, as there are any number of reasons for a civilian to make contact with police, to call for their own safety, to file complaints, to follow up on matters that they are dealing with as regard to the police. And in this specific case, Mr. Christensen's intentions were to file charges against Officer Karpuk for assaulting him. So he sought the St. Clair Shores Police.
So why tip off the police? You're going to go to his church. Ha, I think he said. Hello, that's what he said.
So I don't think it's necessarily tipping him off. I think it's more, as he stated in the other call and in his Facebook posts, he wanted to seek the guidance of the pastor. This is a pastor of Officer Karpuk's church. This is somebody that not only knows Officer Karpuk, but that Officer Karpuk trusts. And he just wanted to be able to seek some insight and guidance from that pastor. It's not necessarily I'm gonna come find Officer Karpuk. It was specifically to seek that pastor.
I think he says that after the fact, right? So, I mean, that isn't the first message that comes out. The first message that comes out is, I'm going to his church. And then, I mean, we could also, I guess, there's an inference.
Yes,
Yeah, with a
he's
surprise,
going to get a
right?
surprise.
And an inference can be made, he probably thought about that and was walking back his comments with the Facebook post as well. And, you know, the subsequent phone call. But I guess I'd like to also have you focus on the argument of what should the district court have been looking at in its bind over decision? Because the district court talks about these posts, but was that the proper thing for the district court to do?
Correct. It was not. This is a First Amendment issue with regard to those Facebook posts. They are protected speech. And while the people state that true threats are a question of fact for a jury, when it is a First Amendment analysis and it's protected speech, the courts retain that power as a matter of law to make that determination. And
I'm going to direct your attention to the elements of what the people had to actually show and whether the court looked at those elements and conducted the correct analysis.
okay, so with regard to the element of the unconsented contacts, simply posting on one's personal Facebook doesn't mean that a defendant intended for the unconsented contacts. He was simply airing his grievances about the criminal justice system and his interactions with police or their lack of follow-up and things of that nature. And he did not personally tag Officer Karpuk. Additionally, there's no intent to threaten, terrorize, or harass when someone is seeking an outlet. So many people go to posting on their own personal Facebooks. Additionally, he mentioned the pursuit of civil action, and that is not a threat, but that's within someone's rights to take that lawful route of pursuing civil action, which he did in fact do. He made a complaint, and I personally don't know where that went, but he did make steps towards that. They were not threats of a violent nature. And to say that this was threatening must be viewed by the perspective of a reasonable person similarly situated in Officer Karpuk's position, which is as an officer. He is a public figure, and he even stated that he's received death threats before, and he is at the front line of action. He's been an officer for decades at this point. So it's not just, oh, would an average citizen be threatened by this? It's someone similarly situated as Officer Karpuk.
Well, just because an officer has been threatened with a death threat before, then they should be less inclined to take a death threat seriously.
Well, that's the difference. This is not a death threat.
Well, I mean, any threat of violence, right? Like if I presume that that was a threat of violence, so just because an officer has had threats of violence before, that he should just accept that and that it wouldn't be reasonable for him to be frightened, threatened, harassed, intimidated by that. Counselor, do you want us really to adopt that approach?
I understand what you're saying, Your Honor, and that's why the statute itself does have that separation of the individual's perception of the threat and harassment, whether they personally felt it and whether a reasonable person would. And again, taking all of it in conjunction, seeing that, he posted about wanting to talk to the pastor, saying that he was seeking civil action, and that's why that's the reference to his pension. Those things do not amount to a threat of violence.
It seems to me he could have done all that without posting a blasted word on Facebook. Isn't that really the problem? I mean, he's putting it out there in hopes.
And there are many people who criticize the government and criticize police officers, whatever the case may be, and their outlet is on their own personal social media, whether it was a public post or a private post just for their friends. It's still an outlet that is permitted by the First Amendment to allow people to post those feelings of dissatisfaction with the government, with their interactions with police officers, things of that nature, which is what he was doing. He was expressing his dissatisfaction and his hopes that the civil route would be taken into consideration, in hopes that officers that, the allegation of Officer Karpuk assaulting my client would be one day taken seriously. He was just posting about his grievances and his hopes. It was not an indication of any threat of violence towards Officer Karpuk. And additionally, I want to circle back to those unconsented contacts. Officer Karpuk had indicated that he received contact by the Monsignor and by his supervisor. those are not unconsented contacts that were prompted by Mr. Christensen. He interacts with the Monsignor, he interacts with his supervisor. If that were the case, then we would have to consider your supervisor calling you to pick up a shift, or the Monsignor or anyone from your church calling you to participate in a fundraiser, anything related to those matters, to be unconsented contacts. But
It seems to me though, counsel, what you're asking us to do is weigh evidence.
I
And
understand.
that seems to be a jury function, not an appellate court function.
And the main thing here is that this is protected speech. This is First Amendment speech, which is in the court's purview of a question of law. This is a matter of law, whether these posts, these statements were protected speech, which we argue that it is.
I get that law enforcement, just like anyone else, is not above reproach. There are certainly channels that can be utilized, but when, again, what's uncomfortable to me is putting it on Facebook, and he doesn't say the first time, I want to talk to his Monsignor to see if he can help with this situation. That isn't what he says. I'm going to his church. I have a surprise for him. I mean, again, maybe his intent was, I'm just a hothead blowing off steam. Lord knows we have a lot of those folks in the world. But again, you're asking us to weigh that evidence in the light that your client wants us to see it. I just don't see how this doesn't, need to be resolved by a jury.
Especially when the bar is, probable.
And even if we were to separate the phone calls from the posts themselves are much more an argument for First Amendment protected speech. If we were to separate those two, again, there are, and I did cite that in my brief as to why these posts are such important avenues for people to express themselves and why it is a protected category of speech. Again, those posts, there is nothing threatening in those.
When we have shooters showing up at synagogues and places of worship and killing people, I disagree with that. That is the contemporary state of our society. I don't think it's just, I'm writing Dear Abby. I know that's what he says. I know that's what you're promoting, but you don't have my vote here. I'll just be very honest with you. You don't have my vote here, counsel.
And again, there was no threat within these posts. He did not even, there's no evidence that he went to the church. There's no evidence that he and Officer Karpuk interacted outside of their official police contact where he was seeking assistance from the police or when the officers were arresting him on charges. Other than that, there was no interaction that would have fall under the stalking statute or the unlawful posting. There was no threatening on Mr. Christensen's behalf. I was waiting. I thought you had a question. I apologize.
2 minutes left.
Thank you, Your Honor. I would rely on my brief and the requested relief therein. Thank you all.
Thank you.
Very much, Counselor. All right, this matter has been submitted. Calling item number 13, docket number 377326, in Ray Collins minors.
May it please the court, Brandon Mack on behalf of the respondent mother.
The fighter who shows up every time. It is great to see you.
I was about to say, nice to see you.
Well, maybe we don't get put at the very end, No, we had a whole contingent from St. Clair County back there when the court was asking, if M25 was Lake Shore, we all wanted to raise our hands. So drive on M25.
Counselor, you have 15 minutes.
And I won't use it, all of it, and I'll reserve 2 minutes for rebuttal.
Oh, I'm sorry. We
Yeah,
have
we have-
somebody.
Panel, I don't see Miss Moore in the queue for the other side. She's been there all day and now she's not there anymore, unfortunately.
Okay,
So,
we'll be proceeding just with Mr. Is it McNamee?
Yes, and I've been communicating with her some more too, and she was planning on being here, so, all right, I want to start with the best interest briefly. This is a very difficult case in that the two barriers are mental health and a cluttered apartment that's only 600 square feet. So, before people in a cluttered apartment or 600 feet, I mean, it's hard not to clutter it. The thing I didn't quite understand is, the ages, they're 10 and 7. And it was rare that the 10-year-old testified that he wants basically to not have mom be bouncing around, and he supported termination, and he had his own attorney. That's pretty remarkable for a 10-year-old. 7-year-old didn't take that position through the attorney guardian ad litem advocating for him, because the attorney guardian ad litem did not want the rights terminated, and pointed out the reason why is that the foster parent wasn't going to adopt, and that there was no likelihood that these two children would be together. And the facts are largely, a lot of them are uncontested, that the 10-year-old was having to do a lot more parenting, or having to be older because his mom suffered from mental illness that caused her to get moody, be rude, all things that aren't going to help you when you're negotiating with DHHS. If you have those things, you're not going to, what do you got to do? You got to get along with DHS. Well, sometimes that's hard for people with disorders such as she had. And then the second thing was, she had gone through this stage where the children were 10 and 7. I mean, I have a 10 and an 8-year-old. I think I'm on easy street now as comparatively to where I was, when they were running around just trying to make sure they didn't hurt themselves. There's Miss Moore. So the high maintenance stage is over. And so now we're in a stage where they're a little bit older, and now the determination is, now we're going to terminate, and the evidence showed that they had a really close relationship. She had a really close relationship with these kids. She had done well enough to get unsupervised visits for 6 months. So she showed progress. So that barrier had shown that she was able to at least get her home in a condition where they could come home. And when you consider best interest, and it's very rare that, I would say the best interest is sometimes like an afterthought. It's the saving the life net, and we don't argue it a lot. But if you look at it closely, and I think one of the reasons we don't argue it a lot is because it's never really that favorable to a parent that's facing termination. It just isn't. But in this case, I think it is, because specifically, we all both cited White, Miss Moore, who tried this case at the trial level, was very professional, called a bunch of witnesses. There was 4 days of trial. The case was presented in a professional manner, a thorough manner, but it came out that, the compliance with the service plan, that's something you consider with best interest. You look at it, how did the parent do with the best interest? The compliance with the service plan, she did it all. She did every bit of it. You consider the parent's history with visitation under the best interest. That's a factor to look at. Her visitation was awesome. You can consider the possibility of adoption. Well, we don't have an adoption. we don't have them staying together. So that is why the attorney guardian ad litem did not recommend termination, because I think he correctly applied those best interest sections. And then when you transition to termination, and the factors that the conditions wouldn't have been rectified, well, first you start with a 7-month delay in starting services. The parenting time occurred at McDonald's, which was very difficult. The only rule, I know, but I think this case showed why it could be very difficult to do them at McDonald's. And the parenting time was much better when it was moved to home. It was better in the home. It was easier in the home. And I get it that circumstances, in this case, she was in the emergency room for, a mental health episode. That's why the kids are removed, and I get that those situations exist, and then they result in imperfect situations where you have to do a parenting time at McDonald's. But you can also take into fact that it is parenting time at a McDonald's. And then the next thing is she attended the visits, she was prepared, and that they got the records at the end, and it showed that she was treating monthly with a psychiatrist, or monthly with a psychologist, and every 3 months with a psychiatrist, and that she was taking her medication. And the only real service she was provided for her mental health was she was given psychological evaluation, and then she was told to follow up with outpatient counseling, and then let's see how you do. And she was also ordered to comply with all the laws. She passed. There's no criminal conviction. She was ordered to maintain a legal source of income. She did that. She was ordered to maintain safe and suitable housing. She did that through periods of time. And the thing I'll say about that is, wasn't perfect in the beginning. Gets cleaned up, and it's good at the end as well. There's times in the middle where they say it wasn't good, but they also acknowledge that they also went like 5 months without inspecting the home too. So there's that to say into consideration, is how often were they inspecting the home? The testimony was there was at least a 5-month gap where they didn't even look at the home. So if that's, if your 2 barriers are 1 and 2, and you take a 5-month break for one of them, I think that's a strike against you. And the thing I'll end with is the supervisor said that she witnessed a decline in the mental health, and not making progress with respect to the mental health barrier was the primary reason they terminated, in my opinion, looking at the record. But you didn't have any medical testimony. They didn't call a therapist. They didn't call anyone associated with them that treated the mother's mental health. It was not called any of the treaters. So all of your testimony about her declining mental health didn't come from any of the treating professionals. They came from observations from foster care supervisors, parenting time coordinators. And I think that's important, because if you're going to say that her mental health never improved, her mental health declined, I think you need testimony from a mental health professional that has the capacity to testify in that capacity. With that, I'll leave my 2 minutes for rebuttal.
Counselor. All right, we do have Miss Hillary on, or I'm sorry, Miss Georgia on at this point on Zoom.
Oh, I'm sorry. I'm Hillary, Georgia, and I wasn't sure how the court wanted to proceed in terms of order, but because they're consolidated.
Yeah, my apologies, continue.
Did you want me to go?
Yeah,
Okay, all right. Just for the record, so it's clear, my name is Hillary Georgia. I represent Mark Collins' father in this matter. And I know you're familiar with Brandon, and so I let him do all the heavy lifting this morning while I sort of sat at the table. But in all seriousness, I do echo a lot of his arguments, because I think what was going on with these parents was very, very parallel. And in a lot of ways, that's the worst part about it, because we have 2 parents that are both dealing with mental health crisis and mental health issues. And when we don't, when we look at this case, and I know that this court hears a lot of cases, we're not dealing with people who are using drugs. We're not dealing with people with housing instability. We're not dealing with abuse here. What we're dealing with are 2 parents that are really struggling mentally. And I covered my substantive arguments in my brief, and I'm not going to rehash those. I'm here just because it is important for my client, and it's important for me to present myself for questions too. But the one thing I wanted to point out was there were periods of great progress in this case, and I take the words great progress directly from the transcripts. And that's what's the hardest part about this. The things that my client had to do to address his mental health condition, he has to take medications that make him tired, that make him act erratically.
So everything he was trying to do to counteract the mental health is also making him more challenged in the parenting role.
So,
Um,
so let me
yeah,
back up a second.
sure.
We've been talking about this. So my notes, tell me if I'm wrong. My notes say that, that the issue of whether or not the trial court, best interest findings, that's preserved, but the challenge to the reasonableness of the efforts for unification, because we're kind of blending all these things together.
Yeah.
That was not preserved, correct?
Are you going to the response that Ms. Moore made in the trial court that it was not preserved, that the reasonableness of the efforts was not appropriate? Okay. No, I would agree with you. I mean, the record is what it is. And I'm not suggesting, I'm not trying to inject an unpreserved argument into this, but I'm saying that when you look at what the trial court found, and particularly when it comes to best interests, I do think that you have to look back at this. Because whether the statutory grounds for termination were found and whether it was in the best interests of the children to do so, does have to look at what was really going on with these people. I mean, it's mental health, and that's a difficult hurdle for them to overcome. So I don't want it to appear that I'm trying to backdoor that argument in, but when I've dealt with best interest arguments before, they do kind of become a collective of everything that was considered before, as well as some new things. And I think that when you look at best interests in this case, you do have kids that have a relationship with both of their parents. You do have these periods of progress. You have a GAL that advocates against termination at the trial court level. And I think that that's worth noting, because again, we're not dealing with the traditional abuse, substance abuse, homelessness, lack of finances. These are people that are doing the very best that they can. And it's not amounting to enough to be able to keep these kids with them. This is a family unit, and it is a bonded family unit. And I think that weighs in my client's favor as far as best interest too. This is not a split up family. This is not a situation where the kids have been away from them. They were raised together, mom and dad and the kids together as a bonded family unit until such a time as they were pulled apart in foster care. So I'd rather answer questions. Again, I've stated a lot in my brief, and if there are questions that the panel has, I think my client is better served by that than me just reiterating what I've written down.
I have one.
Yes.
And it's more for my own educational benefit.
Okay.
And that is, I was a circuit judge and had felony docket and a family law docket excluding abuse and neglect. So pardon my ignorance. But I know on the criminal side, there's been a massive funding of attorneys for criminal defendants, and it also extends to other resources, be they experts, etc. And when Mr. McNamee made a comment about experts, that triggered in my mind a question. I first of all, I don't think you're funded like MIDC.
No.
Right? You get whatever the county is able to pay you, which sometimes can be a dearth.
That's correct. And I should indicate I have represented parents in this capacity only on appeal. I have not done it in the trial court. So I'm kind of limiting my answers to that. I don't know specifically what was available at the trial court level, but we do not, I do not believe that we have anything comparable to MIDC.
Okay. And so Mr. McNamee can think about this when he gets up for rebuttal. You would not, do you or do you not know whether or not in the abuse and neglect system, whether attorneys who are representing the respondents have the ability to tap into resources so that they can bring with them a psychiatrist for either for any purpose relative to the process.
I believe that the way that would work in the trial court is that the attorney representing them at the trial court level would have to petition the court for those funds. So I think it's a lot like, and I'm kind of answering, I used to be a prosecutor, so a lot of my answer kind of comes from that realm, but it's a lot like the old days with retaining an expert in a criminal case. You have to go to the court, you have to say why you need it, and then the judge essentially exercises discretion as far as what to fund.
And certainly if anyone who has different information, I'm sure will chime in, but that's my understanding.
Perfect.
If that, hopefully that answers your question.
It helps.
Okay.
Thank you.
So at the Court of Appeals, we're really kind of tied into what is the standard of review, not whether or not we would have done something differently. So with a clear error standard, why does your client win?
So by the clear error standard, and again, I have explained the deferential standard to my client, he understands that as well. But in terms of the clear error standard, I think that the one thing I'd ask this court to focus on is the evaluation of what my client did in this time frame with that 7-month gap at the beginning that Mr. McNamee referenced. I do think that it is erroneous to find that these factors have been met when there was a delay in the services starting. I think that goes into it.
Why?
Because you have two people, and I'm going to speak about both parents together here because I think they felt the same about this. When there was a delay in getting services started, and I'm not going to cast dispersions on DHHS. I know that they have caseloads, and I'm not here to say that because you didn't do it perfectly and hold my client's hand from day one, you shouldn't be able to proceed. I understand reality, but these are two individuals who are struggling with their own mental health in addition to struggling with trying to reunify with their kids. And when you have, there was a lot of progress, there was momentum, there was a strong bond at the beginning between the parents and the children. And when there's this gap, these parents are not necessarily people who are going to know exactly what to do, how to put the pieces in order, how to get from having the children move to getting to reunification. And so when you have that gap, you lose that momentum. And I know that we should all be motivated to have our kids with us, and that, that's kind of the overarching assumption here. But you have to look at these individual parents and their own limitations, because when somebody wasn't there to kind of get the ball rolling and keep the ball rolling, they became demotivated. Their mental health suffered because of it. And the bond between them and their children suffered too, because these kids are moved into foster care and that bond starts to deteriorate. So I understand that the court reviews this based on a clearly erroneous standard. I know that this court will review the transcripts and the record, but I do think that that is a significant point, as well as everything that we have both said before about best interests. Thank you.
Laura, Roberto?
Hi, good afternoon. Can you all hear me?
Oh, yes.
Yes.
Good afternoon. May it please the court. My name is Phoebe Moore. I'm here on behalf of the Sanilac County MDHHS. I'm terribly sorry. For 4.5 hours I was on my system and it just left me. So now, unfortunately, I'm on my phone. Nevertheless, I certainly disagree with both my brother and sister counsel, who we've all worked with before. They do a fine job, but I disagree certainly on this case, which I've quite frankly invested a large portion of my life into the last 6 years. There's no firm conviction on this record, this whole record, which is voluminous in terms, and as well as the other cases, that was any error, of course, committed by the lower court. And I don't believe that this court will be left with any type of conviction that any kind of mistake was made. Judge Rick, first to your question, I represented parents and children actually before I switched over to represent the DHHS. And you do have to file a motion and you can easily get those expert fees approved. Similarly, I would have to actually just ask my client. So I don't normally just, subpoena physicians either, but they have to approve those fees. Unfortunately, recently they didn't allow my travel to the Court of Appeals, which is a real bummer because I love being there in front of you, especially with an awesome panel like this. It's a loss, but due to funding, I'm not able to travel either. But the second question that was brought up by Judge Maldonado, I believe that, why did this delay? Why is this delay somehow Mr. McNamee's argument and Ms. George's argument? I absolutely disagree as well. First of all, I don't think there really was a delay. You could call it minimal. I looked at this because Mother's brief pointed this out. But if you look at the actual psychological evaluation, which is dated February 29th, 2024, and both parents went on that same date, February 29. In the psych eval itself, I think it's the first paragraph, the psychologist says that this was referred to him on 11/28/23. So the evaluator said this was referred to me on November 28th, and this date is February 29th. So 3 months later, the psychologist is writing the report and visiting with the parents. Whose fault is that? Certainly not DHHS's. The initial dispositional hearing was November 21st. The initial dispositional order was November 29th. So a day before the order actually comes out, ordering DHHS to start these services, the foster care worker referred it to the psychologist. So there's absolutely, the speediest time in terms of referring them to services. There was a couple month delay, but yet we got the report back, and then they wanted to go into counseling. We wanted both parents to go to counseling. Mother said, I'm going to go to my own counselor online, apparently to MD Live. We couldn't get any of the information. We tried for months to get the information. I was involved even with a subpoena, and where were we going to send it? To MD Live. She didn't want to treat with CMH any further, which is, of course, the community mental health program for the county, because of what was happening. And that was, in fact, these involuntary hospitalizations to the psychiatric facilities. And she was now frustrated with CMH.
But the judge didn't hold that against her. The judge actually gave her credit. I think at the last minute, didn't you get like confirmation that she had indeed attended,
Yes.
significant number of appointments, and what the judge said was, but she didn't benefit from it.
Right. Thank you, Judge. So yes, and so it was her counsel that somehow, got her the right release and got to the right entity. And it took, quite frankly, it was her counsel and the foster care worker working together to finally get these records. And she was going. So that really brings me to my next argument. And that's, of course, supported by the couple of cases that are really important in these cases for the years that I've been doing this. And that is Inri Fry, and I think it's Fry, even though it's Frey. And that's at 297 Mish, 2012 case from the Supreme Court in Inri Ashley. And that's where it talks about, we can't just check these boxes off. We can't just attend these services. We have to substantially benefit from them and show that benefit. So for example, it's probably a bad analogy, but if we go to all of our law school classes, we're not a lawyer. We have to pass a test and we have to apply what we learned. But the Collins here, and she did get married during the case, and she's now Collins, not Tonina Borgia. But they don't show any benefit at all, not consistently. And that is what children need, is consistency and stability. So for example, they have moments, and after that delay, I think that delay only benefited them, so they could get their house ready and things like that, and could get things in order. But in any event, then the children come home, they complain that there's not beds in the home, they're not sleeping, they're not fed, and we have to pull the kids again back to supervised visitation in the fall of 2024. And then, of course, in early 2025, we suspend visits. And forgive me, Your Honors, for not perhaps being as explicit as possible. It's hard when I only have 16,000 words. Of course, I could have extended it, and there's so many exhibits in these cases. But I just wanted to look at, and I'm looking at Exhibit 12 in the trial court, just to, if you don't want to read it, I understand, but it's the family impact phase notes. And I look at the notes, and this is the woman who went from DHHS to help them with their budgeting. She testified, and her name was Jennifer Sontag. She testified at the trial, but if you go to her notes, it's even more specific. This is November 27th of 2024, so about a month before we filed the term petition. And she talks about arriving at the home. It's completely cluttered. She has nowhere to sit down. Tonina's got mascara falling all over her, and she's complaining about her food benefits. And then if we continue to look at her Family Impact Team Phase 1 report, if you go down to 12/10, okay, this is 2024, 6:54 p.m. message received from Tonina that states the DHHS needs to pay her DTE overages and reports that her bill is $200 every month. She reports that she continues to get kicked off the payment plan because of the overages. She reports there is currently a $600 outstanding balance. She reports that she's being forced to live beyond her means and that it is illegal and it's a monopoly of exploitation and is sick. And then 2 days later, she calls back, leaves a similar message stating she needs help with the DTE bill and she needs her medical coverages to be looked into. This is after almost 2 years of services in just this case. And, we could talk about the services in the 2014 case and the 2017 case, is that they can't handle their finances. And all of the parties and all the witnesses agreed that even though their benefits were reduced, there's her Social Security income, that they had enough to live off of if they remain committed to their, budgetary needs. And so the facts in this record, and I'm just picking out one exhibit, but the facts are just full of instances in which these parents simply could not apply what they learned. So did they go? They went to some. But also, both counsel today, as much as I respect them, failed to really address the parenting time issues. And that is really the crux of this case. And I want to get to their mental health, but they talk about, Mr. McNamee talked about, she went to the services, she went to life skills, she attended this. They missed parenting time saying they were sick. They missed Zoom parenting time. Mr. Collins slept through parenting time. He slept through nearly weekends. They, left short, in other words, didn't stay for the entire visit. And so that is where the bond is lost with the children, is their lack of effort at going to visits, complaining about the fact that it has to be at a Burger King or it has to be here. But they didn't really make the effort to say, gosh, let's have a wonderful hour or two with our children. You'd think that any parent wanting their children back after going through this process with the state of Michigan a couple of times now, after a couple of petitions, would understand that they need to make the most of this instead of talking to their kids like they're adults and telling them that this is a horrible situation.
I think that you were having technical difficulties when Mr. McNamee was giving some of his initial argument, but he was going through the best interest factors as the court found them and addressing them from his perspective, which was actually pretty compelling. But what was very unusual, I think, in this case is the fact that these kids are not teed up at all for any kind of stability. They're in a foster home where the foster parents have very clearly stated, we don't want to adopt. And so for DHHS to file termination in a situation that's not, which is, it's more neglect than abuse, right?
Yeah. Thanks, Judge Maldonado, for filling in that blank. And I can address that if you'd like me to.
Yes, please, go ahead.
Sorry, I didn't wish to interrupt. And I appreciate the guardian ad litem's position, but and certainly without question, Judge Maldonado, you know this, that the children's interests are certainly paramount and must remain that in this case. But this idea that, the actual foster parent that they stayed with for the last year in Elma won't adopt means we should send them home. That argument flies in the face of this entire lack of stability. So we're going to send them, if I just look at the record, these kids were removed in 14, then 17, then 23, all because of involuntary hospitalizations. We know where the oldest child has been. He was left at a hospital. He was found walking in the street. I mean, this is what happens when they go off their meds and they don't continue to take care of their mental health. So the alternative then is to send them back, and in 2 years they get removed again. So what we have here, Judge, is a very clear history of these parents' just absolute inability to take care of their mental health needs. And I want to emphasize, I proudly work for the MDHHS by contract. This isn't a prosecutor's office. This is not discrimination in any respect. We took this case again to say, nope, we're going to provide services for these folks because we have to try again with them. And it wasn't just 182 days, Your Honor. It was 19 months of services that we tried and tried and tried again. So they could go into foster care now because they couldn't stay in Almont because that family, they have older kids and they wanted to move on. I would appreciate that. But in any event, their very next home could be their final permanent home. And that would be licensed foster care that, of course, has to go through all of the tests of becoming a foster care family in the state of Michigan. And so it would be far more stable. just to know that we have healthy foster parents. I submit to you, Your Honor, even if they had to change foster homes, it'd be better than being left alone and being left with a vape and weapons out, and your father sleeping and your mother, having an episode, having a psychotic episode. So I think that's really where the trial court boiled down to at this point. Folks, there is a reasonable likelihood that you do not have the conduct or capacity to parent under subsection J, under subsection 3 of the statute, Your Honor, and that we tie in those best interests to say stability, permanence. It's not going to be with mom and dad. And when we look at the preference of the child, we know under In re Trejo and in re Olive Metz that we can integrate the best interest factors, Your Honors, under MCL 722.23. And when we go down that list, do we have permanence of a family unit? We don't have that with the Collins. We have a home that can't be kept up. We have dog feces in a home after 18 months of services. We do not have the capacity and disposition to provide for these children. We certainly don't have a bond any longer. We have preference of one child that is so unique in this case. And Your Honor, I trust that you know that. But this child coming to court to testify, to say it's better off for me to be in foster care. And that is just so powerful in this case. And I want to stress that, that really separates this case from anything other. So when you take this as a whole and you understand the Sanilac County Circuit Court's position with the mental health petitions, as well as the previous petitions in this case, I think that you'll find on this entire record that there's simply just no mistake has been made, much less giving you some kind of firm conviction that you can weigh the evidence alternatively. And I would respectfully request that you affirm. Thank you.
Counselor? 2 minutes, Counselor?
These issues are they're not black and white, but in Michigan they are, because we're one of the few states that don't have any restoration base for a parent to get their rights back. Other states do. You got a parent that is addicted to heroin, is given a year to get better. They can't get better in a year. Heck, if you have a year of stability on that kind of drug, it's not even a drop in the bucket yet. But then you do get better. Guess what? Your kids are gone forever. You never get a chance to see them. They're gone for adoption. And so that's why the best interest section is there, because it is so black and white. And this isn't black and white. If it was black and white, the attorney Gardner Lightham wouldn't be saying that this doesn't support termination. So there's nothing black and white. There's nothing clear. So that's why the best interest is there. And best interest, when the best interest looks at services, it doesn't say benefit. It says their history of compliance. Because when you're looking at the best interest factors for services, was the mom trying?
I think case law says benefit.
When it says in reway, it says in the trial court may consider a parent's history of domestic violence, the parent's compliance with his or her case service plan, parent's visitation with the child, and the child's well-being, will, and care, and the possibility of adoption. So that's where I'm getting it from. But I could be wrong if you read it, but I think compliance and benefit are two different things. I think compliance.
They're very different things.
I think that was a direct quote. When they say compliance with a case service plan, I think it means going through the motions, i.e. going to law school. I think passing is benefit. So I think compliance is doing the services. And the last thing I'll ask, if anyone has any questions, judges, I'll just respond to Judge Rick's question. It's not so much that they don't have funding. The MDIC, we don't have funding like that. The bigger problem is, what do you do with a parent that has a mental health problem and they're poor? You don't have the ability to send them to a psychologist at Henry Ford to assess their mental health. They've got extreme poverty, and you're dealing with Medicare, Medicaid. It's hard to assess a poor person's mental health. So.
Again, Brandon has done the heavy lifting for me, and there's not a lot additionally. Just in response to a couple of the things that Ms. Moore said, again, I want to highlight that delay in the beginning. I know that she's indicated that it wasn't really as significant, but these are not parents that were uncooperative with services. They did try. People would come in, they would bring them Rubbermaid totes, they would pack up the clutter, they would bring in cleaning supplies, they would clean up. These are parents that, when provided with services, they did take action to try and better the situation. And I think that had those services started sooner, they could have made more consistent progress.
The dog, or get the dog, I don't know how the dog got there, but after the place.
I can't tell you exactly the point in time the dog came into the mix. And I will agree with you that acquiring a puppy in the midst of trying to reunify with your children is probably going to make your keeping the home clean problem much harder. Absolutely. Right.
Dog, didn't the dog end up getting removed because of, like, by the authorities, correct?
I don't recall the dog being removed. You may be correct on that. The only thing that I would say about that, and I'm not disagreeing with you in the least, I think that when you add a pet to all of the other issues, had I been able to tell them, don't get a pet, that would have been my unequivocal advice. But I think that just like how they had enough money to make things work, but they always wanted to spend it on toys, this dog is the same problem. It mentally, for them, they thought, we are going to get this dog. We are going to have this dog. This dog is part of our family. We want the boys to come home. From the place that they were engaging with this process, I don't think that they saw it that way. I understand the court's position, but I do think that goes again to the need for services in this case. I know that DHHS has been involved with this family a lot over the years. I can't dispute they haven't. They've been, in and out during the years. But it has not resulted in a termination previously. This is not a perfect environment. It's nowhere near it on its worst day. But when you have one child that indicates that they want to have termination occur for the sake of stability, but the alternative is not stability, you have to go back and look at, these kids are bonded to each other. They are bonded to their parents. The parents wanted to get better, but just could not maintain that. So, I apologize for talking over that alarm. I wasn't tuned into that.
It's okay.
My alarm. Thanks.
This matter has been submitted.
Thank you all.
All right, turning to item number 14. Docket number 371-588, People of the State of Michigan versus Gregory Allen Ringel. We did get a communication that Ms. Young has waived oral argument. Counselor, you've one of the first cases and one of the last cases on our docket today, so it's been a long day for you as well. You have 15 minutes.
Thank you, Your Honors. I will not use nearly all of that time. I wanted to thank the court actually for their courtesies. I think both Ms. Young and I ended up filing motions to restore oral argument, and so I appreciate that. I will largely rest on my brief. I'm happy to take any questions. I think all I would really say is that with respect to the sufficiency of the evidence for the intent of the AWIM and in scoring offense variable 6 regarding premeditation, I think a lot of the facts from the record for both of those issues are the same and tend to overlap in terms of the defendant's actions in firing the gun at his wife and the things he said about when he first had thoughts about harming her and the things that he sort of said after the fact to try to cover up for his actions, which were quite an interesting series of events and stories that you got from the defendant. But I think a lot of those things apply to both of those issues. Are there any questions that I can answer for the court?
We have
the easier cases today.
Great.
We have no questions. Thank you very much for your patience all day.
Of course, you as well. Thank you.
Thank you. Say hi to your judges for us.
Yes, I will.
This matter shall be submitted. And calling the last matter on the docket, item number 15, case docket number 376931, In re TMK. No one is endorsed for oral argument today, so this matter shall be submitted. Thank you.